Hi, everyone. This is the staff attorney. I do expect Judge Krause to join us momentarily. If you would let her know that we do have a court reporter when you're making your announcements for yourselves, so that she's aware of, I think it's Miss McHugh, and uh, and she can understand who that is. And anyone else who isn't clearly labeled, such as I see a Veiraef.
That's Fitzgerald Vera, Mr. Freehoff. He's my partner at Troutman.
Okay, is the Veirae how he spells his last name?
No, it's Veira,
Okay,
and then
and then
the
it's
EF for first initials.
okay, and
There
he
he
goes
is.
by Fitzgerald.
Yes.
Correct.
Okay, I'm going to change your name then, so it's easier for the judge to refer to you. Let's see, Fitzgerald, Veira. There we go. Okay. All right. So I am remote today. The judge is in the office in her chambers, and I do expect she'll be joining us shortly because I haven't heard anything from her about tell them I'm running late or anything like that. So she always does that if she is running late. So she'll be with
Mr.
us.
Freehoff,
Yeah.
and not to interrupt, but I did want to one housekeeping matter. If the judge permits it, I do have a PowerPoint I'd like to share my screen with. I don't know if there are any things on the back end you guys need to do, assuming the judge allows it, but I wanted to give you a heads up.
She will absolutely allow it, and you're able to share screens. That's turned on for the Zoom hearing, so you shouldn't have any trouble with that.
Great. Thank you so
Also, I
much.
just want to let you know that since Zoom is treated as an open courtroom, the minute 9 o'clock hits, I turn on the YouTube recording. So I just want you to be aware that we are now currently broadcasting to YouTube. So if there's any cross-counsel chatter or anything, just be aware that it is technically being recorded. All right, there's the judge. I'll be quiet, and here we go.
Good morning.
Good morning, Your Honor.
Honor.
Okay,
Good
Mr.
morning.
Honor.
Mr. Freehoff tap dancing, I guess, to make sure to fill the space while I was late. I apologize for my tardiness, um, but I am here. And do we have a court reporter who is taking this down?
We
Okay,
do,
so
Your Honor.
Madam Court Reporter. So I'm going to formally call the case for your benefit so you know we're ready to get started, and then I'll ask for announcements from everyone. Have y'all made arrangements with your court reporter regarding cost, payment for takedown, et cetera, whether you want a transcript?
I don't know that we've ordered a transcript yet. I suspect that Mr. Held is amenable to a joint takedown fee.
Yes, we are.
Okay, excellent. I was told that you always got to take care of the court reporter, so I try real hard.
Thank you, and I appreciate that.
Next to
Okay.
the judge, the most important person in the courtroom.
Okay, so Madam Court Reporter, this is going to be a hearing in the matter of DeKalb County, Georgia versus Jeffrey Cown in his official capacity as the Director of the Environmental Protection Division. The case number is 25CV007797. If I could get announcements from the parties, starting with counsel for the plaintiff.
Good morning, Your Honor. William Droz with Troutman Pepper Locke on behalf of DeKalb County. With me here on the Zoom are my partner, Fitzgerald Vieira, and co-trial counsel, Kadisha West.
Okay, and counsel for the defense.
Good morning, Your Honor. On behalf of Director Cowan, I'm Chris Held from the Attorney General's office. And with me on the Zoom is my colleague, Kathleen McCandless.
Okay, welcome all. So I'm going to frame this briefly, which is that we are here on an appeal from a decision by the administrative law judge regarding the dispute between DeKalb County and the Department of Environmental Protection, which basically, as I have educated myself and learned about, relates to the Snapfinger Creek and Polebridge Creek watersheds. I'm sure I'm going to use all the wrong language. I will tell you, quite frankly, I have right next to me a key that I've prepared so that I know what all the abbreviations are, because those were hard to track through reading the briefing and the ALJ's decision. But nonetheless, I'm obviously, the only part I'm clear on is the part that I do all the time, which is I'm clear on what the legal standard for my review is of an ALJ decision. And then beyond that, I have read the briefs. I have read the ALJ decision. Have I fully absorbed the dense nature of all of that information? Probably not. And so all of that is a way of saying, I don't know that you have to start from very scratch, but I do need you to take a little bit of an opportunity to make sure that I am educated about the important facts that are at issue. Because as I said, I have endeavored to try to understand it, but it is very dense, and I want to make sure I don't have any mistaken understandings that are relevant to my decision making. So procedurally, we are actually here because DeKalb County has challenged that decision. And so typically what I would do is, throw it over to the movant, the petitioner, to lay out the basis for their challenge, and then hear from the respondent regarding their response to that challenge and why they, I assume, believe that the decision should be affirmed. Any questions, concerns, or challenges, suggestions that we should do it a different way? Mr. Droz?
No, Your Honor, that is fine with us and sort of what we had planned for.
Okay, Mr. Held?
That's what I'd anticipate as well, Your Honor.
Okay, excellent. Well, with that, Mr. Droz, I will hand it over to you, or Mr. Vieira, whoever I'm going to hear from.
I will be making most of the remarks, Your Honor, unless you have questions, in which case any of our trial team would be happy to talk with you. And if I may, I've prepared a PowerPoint presentation to guide us a bit, and if the court allows, I'm happy to share my screen to help address that.
Okay, thank you. Go ahead.
This is the point that always makes me the most nervous, because my technological skills are not always the best, but let's see if I can make this work.
Technology is awesome when it works, and it's so frustrating when it doesn't work.
All right, let's see here.
Well, so far so good. I see us a PowerPoint on there on the screen, Mr. Droz.
Excellent. That's great. The day started off well. Um, Again, Your Honor, thank you for that. And I'm going to cover what you asked, some factual background and some statutory and regulatory background. But I wanted to start here, which is a bit of a overview and a theme that I think is important that runs throughout the argument that I will make today, as well as we think the record. Just a couple of sort of general concepts. One is what I would term and would refer to as regulatory overreach. And when using that term, what I'm meaning is undertaking regulatory action that goes beyond the statutory or regulatory authority of an agency. The second, a related but different concept, is regulatory burden. And that's the legislative balancing of environmental objectives against the economic and other costs imposed upon a regulated industry or community. And I want to pause on that for just a minute because there's a lot of discussion about the purpose and intent of the Clean Water Act here. And I think perhaps we see things a bit differently than EPD as a regulated entity as opposed to a regulator. And yes, it would be great if every molecule of water and every molecule of air were perfectly clean everywhere in the United States and the world. In a industrialized society, that is just not possible. We need things every time that someone has to flush a toilet or do wastewater. There's going to be some discharge that occurs. Every time anybody cooks a hamburger or manufactures something, there's going to be something that's released from their plant. And so, you know, we don't live in a perfect world, and that's what we mean by legislative balancing, that the legislature comes in and says, okay, these are the things which we can live with because we want to have these things that otherwise would be too costly or just couldn't exist at all. And here are the things that we think that an industry or community must do. And so this concept of regulatory burden is important. And I have put one issue down at the bottom, which you won't have to wrestle with today, I don't think. But I thought it important to illustrate this point by showing that the Federal Circuit and the U.S. Supreme Court have recognized that you can regulate so far as to essentially create a Fifth Amendment violation and a regulatory taking of private property. So there is a concept out there that there's no question that that balance can go too far. So I just want to sort of get those principles out there because I think it helps inform some of the discussion as we get down into some of the specifics that we will be addressing here. So here's where I'd like to start. Here are the errors that we think warrant you reversing the decision of the ALJ. We think that the ALJ erred in denying our motion for summary determination and finding that the CNOP, or Comprehensive Nutrient Optimization Provision Plan, those provisions are merely BMPs and not effluent limits. And the reason that distinction matters is that there are different regulatory requirements depending on how those are put into a regulatory permit. The issue here, though, is that, and one I will flag for you now, is I think the crux of the disagreement here between EPD and DeKalb is that EPD looks at BMPs and says, oh, well, it says BMP, so it must be a BMP. We think that's the wrong analysis. We think you have to look at the effect, not just the label, not the form. What's the substance of what that particular regulatory provision does? And that's where we think the ALJ got crossed up, is she just looked at the BMP and said, oh, well, it says BMP. It says BMP in the statute, in the regulation, so obviously it's a BMP. We think, and as I'll mention to the court later, we don't think that that is the substance of what happens here. There are implementation requirements, there are reduction requirements that are contained in this CNOP provision that makes it an effluent limit, not a BMP. Um, and if the court finds that it is an effluent limit, I think we're agreed that there is no question that the regulations require EPD to conduct what's called a reasonable potential analysis before imposing any kind of effluent limit. And so there's no dispute here either that that was not done. So if the court finds that this was in substance an effluent limit, not a BMP, and I think we're all agreed that an RPA or reasonable potential analysis is required, and then it wasn't done, and therefore legally, the court doesn't need to reach the question of reasonable and necessary, which I'll address next. But that's the off ramp. We're done. Legally, that was an improper inclusion of this CNOP in our permits. If the court gets past that issue, though, the legal question, then we think that the ALJ still erred because the BMP provision upon which EPD is relying says that uh, the BMP must be reasonably necessary for the intent and purposes of the CWA. Now, that's why I wanted to lead in with those sort of regulatory burden comments is reasonably and necessary have meaning. They are independent words, as we established in the record, and EPD admitted it's two different concepts. And it's first got to be necessary, and if it is necessary, then it must be reasonable. So there's two steps in that analysis, and we think that EPD below failed both of those steps. And I'll address that later. Um, we also believe that the ALJ misconstrued an applicable regulation by rejecting DeKalb's agency records request, and we think that there is an issue taking all of the foregoing. If the court gets past all of the foregoing, we disagree with EPD in its brief that our home rule challenge is a superfluous argument, but we do agree with them that you don't need to reach it if you decide the other issues in DeKalb's favor. So with that, I'm going to dive in here, and I apologize for the density of this slide. The court's already flagged that this issue does have a lot of weeds, so I'm going to
Well,
try.
yeah, I did spend, like I said, a great deal of time trying to figure out and again make myself a key about what a T bell was and what a WQ bell was. And that may not be how y'all say them. Y'all may say them different ways, but um, all of those things are quite, you are correct, quite dense. So please go ahead.
I will do that, and I do want to thank you, Your Honor, for digging in. I think this is a case that requires that kind of deep thought on the complexity of the statutes and the regulations and the court decisions. And so, thank you for that. That really, I think, is helpful that we can at least start on a level playing field on what the concepts are. Um, the the whole idea of the Clean Water Act, as I sort of mentioned at the outset, is that it's a balance that Congress set so that it can determine what is allowed to go into the waters of the United States. Sometimes that I don't think I'm going to mention that later, but there's an acronym there that may or may not be on your chart, but it's WOTUS, WOTUS, which is simply the acronym for Waters of the United States. Um, and so what the Clean Water Act is designed to do is to determine, make that legislative balance and to determine what is allowable. And the way they do that is through these National Pollution Discharge Elimination System permits. So they go in, anybody that's discharging to something that is waters of the United States has to get a permit. Most of these authorities have been delegated to the state agencies. So in most cases, as is the case here, EPD, Environmental Protection Division of the Department of Natural Resources, issues these permits to people who are discharging waters or wastewater or in some cases stormwater into the waters of the United States that can affect the public. That's sort of what a water of the United States is. And so um, these permits have a sort of a staggered approach, and they different levels of regulatory striation, for lack of a better word. And if you can create technology-based effluent limitations, and that is essentially something that is looking at can we control by technology the levels of certain contaminants or pollution that are in the wastewater, then we can set limits on those, specific limits. Um, if there are issues with whether the technology can control it or not, you can also create the WQ bells or water quality. So instead of looking at what can the technology do, you look at what is the impact on the what we call the receiving water, what the contamination, pollution, etc., goes into. So
Can
we
I
can look
ask,
at that.
forgive me
I'm
for
sorry.
interrupting, Mr. Droz, but can I ask I think this is a very basic question, but is it correct that the dispute here that DeKalb County takes issue with the limitation that's being imposed at all, or is DeKalb County taking issue with the nature of how they've been instructed to manage that limitation?
We are
That,
taking, I'm
okay.
sorry, Aaron.
No, no,
We are
go.
taking issue with whether the limit is allowed at all. We
Okay.
don't think, number one, that they followed the necessary steps to be able to impose this limitation.
Okay.
And even if they did, we think that it goes beyond what they are allowed to do. So
Okay.
at base, we are saying that this provision should not be in the permits at all.
Okay.
Um, So, uh, if, you know, there are an inability to do either the T-bills or WQ bills, we acknowledge this availability of a best management practice. But we think that the best management practice is also circumscribed by some of the restrictions that exist on these other ways of regulating what is going into the water. And I'm going to go into a bit more detail with that in just a minute. And as I sort of teased at the outset, um, in order to um, put an effluent limitation on a discharger, you're required to have this reasonable potential analysis. And what that RPA does is you go in and you look at the discharge characteristics, you look at the receiving water, you figure out whether the water that's receiving the discharge is impaired or not, and then you look at surrounding areas and you determine, okay, on a broad basis, what can those waters receive and still be within allowable limits so they're not unduly affecting downstream water users. So it's a very complex process. It's a very scientific, a technically driven process, which didn't occur here. And so where DeKalb is discharging its wastewater, it is not an impaired water. The impairment that EPD is relying on is some 7, 8, 9 miles downstream at a Lake Jackson.
Right. It's something about a chlorophyll level, which I'm sure I haven't heard that word since ninth grade biology, but um, that's the issue, right? Something about ultimately all of the waterways that are affected, their final reach is to Lake Jackson. And there are, last year there was some designation of Lake Jackson having this concerningly high chlorophyll level. Is that right?
That's right. That's
Okay.
right, Your Honor. And I probably should have digressed a bit earlier. In the environmental world, there's lots of things that are regulated and that can generate either a regulation or litigation. Obviously, some of the most basic are things like stormwater, which may or may not contain any contaminants. It may just be that it's flooding somebody's property. Um, you have sort of a situation like we have here, which is what's being regulated is a naturally occurring substance. So We're talking about nutrients. And then probably at the most extreme level, you have things that are actually toxic that are being discharged. Now, we're not dealing with that. So as the court just pointed out, and thank you for that and the reminder, we're talking about chlorophyll. We're talking about things that occur naturally. We're talking about an algal bloom or where uptake of these nutrients causes plant growth that can create issues in a water body. So at least we're not talking about here anything that is a toxic discharge. That has nothing to do with why we're here. We're talking about nutrients that exist naturally in the environment, and there is some need to regulate them, but we would suggest it's certainly not at the level of if we were discharging toxic substances into a water.
Okay.
So the last point I want to sort of make here on this framework is that, again, the best management practices, or BMPs, which are sort of the lowest level of regulatory control in this striated list, there are conditions in that regulation, 122.44K4, that set out when you can use these. And they can be imposed, number one, when numeric effluent limits are infeasible. And that was the original justification that EPD gave. They changed it later after DeKalb protested and said, well, of course they're feasible because you're working on them right now. And then suddenly we moved into, oh, well, it's for purposes of the supporting the purpose and intent of the Clean Water Act. But when you go down that path, this purpose and intent language is preambled by this reasonably necessary issue. And so that's where we get into the whether it is one, necessary, and two, reasonable. So with that background, I'd like to go to a U.S. Supreme Court case. And this is a very recent case, a 2025 decision of the U.S. Supreme Court. And in this case, San Francisco was challenging EPA's effort to regulate discharges. In this instance, it was a combined discharge of stormwater and wastewater. And the Supreme Court looked at this in great depth and looked at the purpose and intent of the Clean Water Act. And I think this case is informative for two reasons, really. In looking at the Clean Water Act, the court noted that in 1972 there was a sea change in the way that Congress said you were supposed to approach these issues. Prior to 1972, EPA and state agencies like EPD by extension were required to do sort of a retrospective approach and say, okay, we're going to look at the existence of certain contamination and we're going to work backwards and figure out how do we fix this along in this case, a water course. And the Supreme Court said that all changed in 1972. We are no longer going to look at this broad-based retrospective analysis, and Congress has now said, no, we're going to regulate by specific dischargers. So state agencies, you have to go to the specific discharger and figure out what their impact is and place specific limits on that discharger. Now that context is very important here because that is not what EPD is doing with the CNOP provisions. What EPD is doing is a punish the class, broad-based, generalized, well, we want to make water better. And so while we're working on all these other things, we want all of the regulated entities to start regulating themselves and imposing limits on nutrient discharge and reduce those limits over time. Well, that is not what the Supreme Court said regulation is supposed to be about after 1972.
Right, but
And it's yes, sure.
Just to make sure, I mean, but you've made some distinction in your papers and here today about the fact that these are naturally occurring substances. I think the papers mentioned phosphorus and nitrogen. But I mean, isn't there also, I don't know if it's the San Francisco case, but wasn't there also some recent cases where parties were urging that substances that were naturally occurring, like say carbon, couldn't be regulated, and that was a rejected as an approach. And if I am correct in understanding that, then does it matter if these are natural versus pollutant, industrially created chemicals, et cetera? Is the point that, I mean, I don't think there's any dispute that EPD is authorized under the Clean Water Act to regulate these substances, whether they're naturally occurring or otherwise, right?
That's correct, Your Honor.
Okay.
And we don't dispute that. But having said that, we also think that when you look at the legislative balance and when you look at the issue of how do we determine the scope and the need for the regulation and the regulatory burden, that you would look at something that is a naturally occurring substance different than you would from a toxic substance that could harm people immediately, not create algal blooms in a lake 8 miles downstream. That there are some policy choices and there are some regulatory burdens that would dictate that you would look at those two differently, even though they are both regulated, if that makes sense.
It does.
So just to finish out on City of and County of San Francisco, what the Supreme Court took issue with is what they termed end result requirements. And so there's no question, as the Supreme Court found, that EPA could regulate in that instance. But what EPA could not do was basically tell the entity to regulate itself and figure out how you're going to make life better in San Francisco Bay. And the Supreme Court was very clear on that and said, look, EPA has tools, it has scientists, it has studies, it can seek information requests from regulated parties, but it needs to set, just as the change in 1972 expected, specific limits on specific dischargers as a means of regulating under the Clean Water Act.
Sure, but
And
it wasn't the EPD's argument here, though, in the lower, in front of the ALJ, that you're trying, that the CAB is trying to characterize it as an end result limit, but that it's not really an end result limit, right? That ultimately it might have the effect of changing the end result, but that if it didn't have the effect of changing the result, that wouldn't mean that DeKalb County wasn't in compliance, right? And if that's correct, then that's not an end result limitation. Can you address that aspect of it for me?
I can, and I'll do it two ways, one directly and then one in the context of the San Francisco case. The direct answer is that there's no question that there was not a site-specific nitrogen limit that was placed on DeKalb. There's no question that there was no analysis done as to what the impact of any of the regulated, including the phosphorus discharge, were on the South River, which is the receiving water. So by saying, oh, what we're trying to do is improve the water in Lake Jackson downstream, and keeping in mind during or through that stream reach, there are multiple dischargers, not just DeKalb, who are contributing to whatever is going on in Lake Jackson. And oh, by the way, we didn't look at any of those either. So we don't know if DeKalb is a 1% contributor, a 90% contributor. We have no idea. All we're trying to do is improve the water in Lake Jackson. And that, we think there's no way to characterize that as anything but an end result requirement. We are trying to improve the water in Lake Jackson. That is our end result requirement. So that's, we think, the most direct answer is they're just wrong. It is absolutely an end result requirement.
I guess my question is stating an end result goal the same as an end result requirement? Because saying we want the water in Lake Jackson to improve is clearly an end result goal. But again, if all they're asking, if it's correct that what they're asking DeKalb to do is to regulate, is to adjust something they're doing in a particular way that they hope will have that end result. That's not the, I guess my question is, if they say do this thing to Cab County and y'all do it, and the nitrogen levels don't reduce in Lake Jackson, DeKalb County has still complied with what they were ordered to do by EPD, and they wouldn't be in violation of the permit that they were given, right? Or am I?
Well, no, not necessarily, Your Honor.
Okay.
And that's part of our concern here, and part of the reason why um, we think that the Supreme Court and the statute and regulations speak in a clear voice and saying there have to be specific limits, because EPD, once we submit this plan that they're asking us to, and their EPD always reads one provision of the plan out of existence, which is you must implement reductions. Now, they're not saying what you have to get to. They're not telling us if you get above, um, a certain measurement that you violated the permit. We think you should have to do that because then we have clarity on what we have to achieve. But by saying that you still have to implement and reduce, it does two things. One, they can always take issue with whether we did enough. And we have no clear way of saying, well, of course we did because you said it was this number and we hit that number or below it. But second, it opens the door to citizen suits under the Clean Water Act. Separate and apart from EPD, a citizen can look at that permit and say, you know what, I don't think DeKalb's doing enough, so I'm going to sue DeKalb and try and enforce this vague language and try and make DeKalb do more. So we don't think that this implement reduction language that is in the CNOP is anything other than a vague approach to this that gives us no certainty. And I told you I'd tie back to San Francisco. One of the things that was discussed in San Francisco is that the benefit of these clear mandates is that if you are a regulated entity with a permit, you have what's called a permit shield, which means if some citizen comes in and says, oh, wait a minute, we don't think you're doing enough, we could say, oh, no, here's our permit. Here's the limit in our permit. EPD or EPA said we hit that limit and we're good. You can't sue us. And the court said that's a valuable right, that is part of the trade-off in that legislative balance, that if you hit your numbers, we're going to protect you from potential liability. So number one, when you have these vagaries, you deprive the regulated entity of those rights. And then secondly, the context of San Francisco, I think, really matters here, because the first argument that San Francisco made was, no, all of these regulations are effluent limits, and so therefore they have to meet the strictures of effluent limits. Now, and this is what EPD likes to point to. The court said no. There can be other regulated forms of control by an agency. But here's where the context comes in. If that is the case, if you accept the premise that it is not only effluent limits that are subject to no end result requirements, then that means that all of the regulatory tools are subject to the no end result requirements, including BMPs. So EPD likes to forget about that first determination by the court in San Francisco, but read consistently throughout that opinion, you have to accept the fact that the no end result requirements not only applies to effluent limits, it applies to BMPs as well. So we think, again, that they have, one, we think it's an effluent limit because it's restricting our abilities to discharge to a water body that's not impaired. But second, the end result requirement that San Francisco struck down is just as frail in a context of a BMP as it is in an effluent limit. So that's a second reason that San Francisco says this can't stand as a matter of law. So we do believe that the ALJ misapplied the law in holding that these CNOP provisions are not effluent limits. And if you look at those provisions in the context of the ALJ's decision on the motion for summary determination, the ALJ just ruled that it was unnecessary for these permits to comply because with the issues of the RPAs and things that they have because of those BMPs. But that's not what 122.4417 says. Merely asserting that an effluent limit is not WQBL doesn't make it so. And the requirements of the CNOT provisions, when you actually look at them, are that they do function as an effluent. They are all aimed to reduce nutrients and require us to use that CNOP to limit the discharge of total nitrogen. And it requires numeric targets. DeKalb has to regulate itself, which is exactly what San Francisco said that a regulated entity should not be required to do. That is in the CNOP provisions itself. And if you look at the testimony from the witnesses from EPD, this was Whitney Fenwick, who's the EPD manager of wastewater regulatory program. We talked with her about whether EPD should be conducting a reasonable potential analysis, and this is her testimony. I cited to her the regulation that said that a permit writer must perform a reasonable potential analysis when they identify a pollutant of concern. She acknowledged the language, and then when asked, it uses the term must, which is a language of command, correct? And she says, I would agree. And she further indicated that under the language at page 9, that a reasonable potential analysis should have been performed on those nutrients. Correct? Correct. So I know EPD likes to cite to a one-off out of context statement from her where she said that, well, I don't think that you have to do an RPA for a BMP, but that doesn't change the fact that you have to do an RPA for an effluent limit. And she acknowledged that. And she further acknowledged that there was discussion between EPD and EPA. And this is in the hearing transcript, and it comes from our Petitioner's Exhibit 65, which was a May 2022 nutrient roadmap between EPA and EPD. So these are the agencies talking. Excuse me. So even going beyond Ms. Fenwick, the agencies, EPD wrote a letter to EPA in this roadmap and said that EPD agrees with EPA that whereby facilities discharging pollutants of concern such as nitrogen directly to or upstream of water bodies, read Lake Jackson, with total nitrogen water quality standards must undergo an analysis to determine if the discharge has the reasonable potential to cause or contribute to in-stream water quality standard. And I asked her, did I read that correctly? And she said, yes, I did.
Mr.
And so,
Jones, let me
yes,
ask you, many of my questions I think you'll find are going to be much more basic to make sure I sort of have an understanding of how some of these more granular issues fit within this larger structure. So understanding at least part of DeKalb County's argument is that because this is something different than what EPD characterizes it to be, that a reasonable potential analysis was necessary. So my question is, what would have changed had EPD done a reasonable potential analysis? What would that have given you, or how would that have changed the outcome for DeKalb County?
if a reasonable potential analysis had been done, then DeKalb would have known, one, whether or not it was contributing anything that required further activity other than its fully optimized plants were already providing in terms of wastewater discharge. Two, if it was determined that DeKalb was contributing in a way that required some kind of regulation, further regulation of its wastewater discharge, it would have given us a specific target that we would need to hit to assure that we were not in violation of our permit. And therefore, it would also give us the permit shield and the certainty of knowing that we would not be subject to beyond regulatory enforcement, but citizen suit liability associated with any of the discharges that we were making. So that's how it would change. One, it would have told us whether or not we're even contributing to the problem. And we're talking about ratepayers' funds here. So every time we put in a new machine or we dial up the removal characteristics of the wastewater um, management machinery or buy more chemicals, every time we do that, we are increasing the cost to the ratepayers of DeKalb County. And so before we impact, you know, citizens in that way with an essential service, it's not like we can say, oh, well, I'm going to give up, having uh, sewer service. It's not something you have a choice about. So before we impact a whole class of ratepayers with additional costs, we think there ought to be some front end regulatory certainty that one, we even need to do that at all, or two, that if we are doing it, we're not overshooting. So if a reasonable potential analysis said that we were only to be contributing X amount and we went further and spent a bunch of money and we were dialing back our wastewater to Y amount, then we've just wasted a lot of money that is otherwise something that could be determined by good science. So hopefully that answers the court's question.
It did. Thank you.
Um, so, we think it's clear that we think that EPD's position here is a convenient litigating position to basically be saying that, oh, well, it's just a BMP, pay no attention to the BMP, when they're telling EPA that EPD was in agreement in May of 2022 as to the need for reasonable potential analysis when you have a pollutant of concern, such as nitrogen. So we think it's clearly inconsistent with what was being told to EPA and the agencies being in agreement that this reasonable potential analysis was at the heart of regulation in this nutrient space. This is, from the actual comprehensive nutrient optimization plan language in the permits, and they are fairly close to one another between Snapfinger and Polebridge. And if you look under that annual report language at the bottom, the B little Romanet 2, what DeKalb is being required to do is provide a detailed progress report that provides a summary of the reduction goals. So we have to come up with our own reduction goals instead of being told by the agency, as San Francisco expected, what the regulatory goals are. We have to come up with numeric targets on our own without knowing what, if any, impact we're having on the non-impaired water or the other dischargers downstream, what their contributions are. We have to then describe how those goals and targets were achieved, and then what the BMTs were that were implemented. And we then have to set new reduction goals. So without even knowing whether our first goals were sufficient or not, we then have to set new reduction goals and targets for the following year. So, again, saying that this is not impacting DeKalb or saying that this is just aspirational is not consistent with what DeKalb is being required to do. And, again, in that section A, we're being required to identify, and here's the key word, implement operational adjustments aimed to reduce the nutrients. Identify and implement. Implement is not a word that says, oh, you just give us a little paper tiger report. It's like we have to do things, spend money that the ratepayers potentially have to pay for, and we could be wrong. We could be spending a lot of money that the ratepayers would not otherwise have to pay. So Again, that is why City of San Francisco says it's not on the regulated entity to come up with its own standards. It is on the regulator to do that. So, you know, there's a consistent theme here that the agencies are in agreement that they should be doing this RPA. There's a consistent theme here through the Supreme Court decision that it's a regulated entity's duty, not DeKalb's, to determine what the parameters are that we have to meet. And just trying to run to the cover of a BMP is inconsistent with all of those things. Just to sort of wrap up this section, EPD didn't examine whether or not discharges from Snapfinger or Polebridge had any reasonable potential to contribute to nutrient-related water quality violations. Ms. Fenwick, as I noted, testified that the CNOT provisions were solely based on the geographic fact that the facilities are upstream of Lake Jackson, not based on an analysis of facility discharge data, nutrient concentrations, or in-stream conditions in the South River. That is an end result requirement. And then Fenwick further confirmed that the CNOP requirement was applied uniformly to any facility upstream of Lake Jackson without regard to the actual discharge characteristics of the individual facilities. So now not only DeKalb, but everybody else downstream could guess wrong and spend a bunch of money for no reason when EPD has the ability to use science to determine exactly what the contributions are from each discharger and determining whether or not on a broad-based basis there is a need to dial back any of the discharges at cost to the regulated entities. So I'm going to change gears here, and to this point we've been sort of talking about why the court can determine as a matter of law that these provisions are improper and should be struck from the permits. I'm going to pivot now and move to the question of, if the court were to decide that these permit provisions were not effluent limits or that they were not end result requirements, what are the limits under a best management practice of whether or not these requirements that they're imposing on DeKalb are reasonable and necessary? As I sort of already mentioned in connection with that legal argument, there's no site-specific evidence that shows that these CNOT provisions are necessary. DeKalb and Snapfinger, and I probably should back up, you asked for some of the key facts, and I'm not sure I completely covered that. The Polebridge plant has been in operation for some time, and we believe that it is optimized under its current ability to limit nutrients. And what you can't necessarily regulate is going in and under the guise of optimization. Optimization means what's already there. Spending capital dollars to expand a plant, put in new machinery, that is not optimization. So I just want to make that distinction, number one. And then number two, the Snapfinger plant was just upgraded with supervision from EPD at a cost in excess of $260 million. And so it's going down through its sort of normal shakedown when you have a new plant coming online. But, being told that we have to figure out what our own standards are after going through all of this regulated construction makes no sense at all. Why would DeKalb spend $200+ million with EPD supervision and not create a plant that was sufficient to protect water quality? So that's why, again, there's just no scientific evidence that we are, in fact, we DeKalb are contributing to an impairment. There's a way to do that, and it's undisputed that EPD did not do that. And there's no evidence in the record that these nutrient discharges are causing or contributing to violations in the South River or Lake Jackson. And the evidence that we have is that the phosphorus and nitrogen load are not being exceeded by the facilities. So we're not, even though there is a limit on phosphorus, we're not exceeding that limit. So we are within our permit on phosphorus, and nitrogen is not regulated at all in terms of a permit limit. So just to quickly run through, Your Honor, DeKalb put up unrebutted scientific evidence with an expert, Ms. Nomura, who looked at the discharges and it was her opinion that the nitrogen concentrations in Lake Jackson are below the 4 milligram per liter standard. The phosphorus loads are below the 179,000 pounds per year cap. She found, or it was her opinion, that there was no scientific basis for excessive phosphorus loadings by these facilities. And she found no scientific evidence that snapfinger or pole bridge contributed to nutrient-related impairment. And she based these conclusions on a review of actual facility discharge monitoring reports. Obviously, as a regulated entity, we have to produce to EPD what we are discharging. So based on her analysis, we are not a problem, and requiring us to incur costs and to bill ratepayers for additional technology when it's not justified is contrary to the expectations of the Clean Water Act and the decisions of the courts interpreting it. EPD's only answer was to basically show that that they didn't have any data showing that the nutrient levels directly from snapfinger or pole bridge were responsible for that condition in Lake Jackson. And they couldn't assess actual nutrient loads entered the lake because they couldn't identify what portion of the nutrient budget is attributable to CAB. And again, we think that is an end result requirement, as we were covering earlier. So it's not necessary to force DeKalb to come up with and achieve reduction goals, identify and implement strategies to reduce those nutrients further when there's no indication there was a problem to begin with. If there's a problem, it's necessary. If it's not a problem, it's not necessary. And DeKalb has no evidence, excuse me, EPD has no evidence to say it's a problem for DeKalb. And even if it were necessary, we certainly obviously don't concede that, but the reasonable prong as well. We had testimony from Kenneth Gobin, who's the Assistant Director of Water Production at DeKalb's Department of Watershed Management. His testimony was unrebutted, and he testified that Snapfinger underwent this $268 million upgrade to implement to state-of-the-art nutrient removal systems, including enhanced biological phosphorus removal as well as nitrogen removal. So, asking us to do more when you're not even showing us we're creating a problem in the watershed makes no sense given the capital investment that DeKalb just made. And as noted previously, EPD saw us building this plant. They saw us doing all of these state-of-the-art upgrades, and they never told us that anything we were doing was not sufficient to protect water from that snapfinger plant. So we really do have a problem with being told that, well, we don't have any science to justify that you should be doing more, but we're going to make you do more, spend more money, charge your ratepayers more, even though there's no indication whatsoever yet that we are a problem. So I think this is sort of amply covered in the brief. What Ms. Nomura looked at was not just whether or not the provisions were necessary, but also whether or not they were reasonably tailored in scope. And it was her opinion that the CNOP provisions were not technically justified. It was further her position that that the CNOP provisions do not account for either existing facility performance or just any obligations based on our demonstrated optimization of the plants. So we take issue with one, whether you can even have these things, but if you can, they're not necessary and they're not reasonable insofar as DeKalb is concerned. Again, this is a cookie cutter across the state policy decision by EPD, not justified by science in any particular watershed. Um, Certainly not this watershed, where there's no scientific evidence to say that DeKalb is contributing to the problem that they're identifying in Lake Jackson. Um, this is a small point, but I think an important one. We keep hearing from EPD that, well, as long as you turn in a piece of paper, we're not going to penalize you. Well, that just doesn't make any sense, because if something is reasonable and necessary, it's got to have some regulatory effect. So just saying that I mean, the argument was made at the trial that all DeKalb had to do was turn in a piece of paper and say, oh, we're doing all we can, and that we would never receive any enforcement activity as a result of that. Well, that is not consistent with the language in the CNOP that says that we have to identify and implement reduction goals. Um, and and Ms. Fenwick candidly admitted that she wasn't the enforcement person, and neither were the other two witnesses. So no one from EPD who actually does enforcement work actually testified and confirmed that that was the case, that all we had to do was turn in a piece of paper and we're fine. Um, so it's inconsistent to say that this is just a check the box exercise and you won't have any enforcement activity, but at the same time say, oh, but it's reasonable and necessary to undertake all of these steps and spend funds and optimize your plants further, even though we don't know what, if any, impact you're having on the watershed. It's just not consistent. Um, Your Honor, I'm not going to spend a lot of time on this. We disagree with regard to the decision of the ALJ on the agency records requirement. We think if you look at the definitional sections of the statute and the regulation, that what is happening with this CNOP, it is a limitation on what our permit allows us to do, because our permit allows us to discharge into a water body. And by saying that we have to, on an annual basis, turn in a report about how we are implementing and identifying reduction goals, that is dialing back our ability to discharge into that water body. So it clearly is. It is a limit on our permit. And so saying that it's not is not consistent with what's happening on the ground or the reality of what a discharger who would otherwise be able to hit a certain target limit. It just doesn't jive with that. So we think the statute and the regulation do apply. It's conceded that there were responsive documents out there that were not provided to us, and we think that that EPD should have been required to produce those. And so we do think, and we also disagree. EPD seems to suggest that our argument became moot because the hearing got started, but it was clear we preserved that issue all the way through the case. It obviously got ruled on by the ALJ. She didn't think it was moot. It wasn't moot. So we did preserve that issue. So in any event, that is a smaller issue in the broader scope of things. And then last but not least, and I do agree with Mr. Held that the court doesn't need to reach this home rule provision unless it determines all of the other prior arguments against DeKalb. But they seem to suggest that it's a binary equation, that if the court decides all the other things for us, that our argument is superfluous. And if it decides it for EPD, then we have no home rule challenge. But what the home rule provisions of the Constitution say are that counties should have the right to govern their own operations consistent with the needs of their particular citizens. So if you're making, in this case, EPD is making, DeKalb to take steps that are not otherwise necessary, are not grounded in science, are not grounded in regulatory authority, then we absolutely have a right to protect ourselves using the constitutional provisions. But if the court decides the prior matters in our favor, we agree that that is not something that the court needs to reach. So, in summary, then, Your Honor, what DeKalb is asking that the court do, um, these permits are not otherwise stayed unless the court enters a stay. If the court determines that it needs to take any significant time to resolve the arguments after today, we would ask that EPD's actions be stayed so that we're not having to prepare these CNOT provisions while the case is under consideration by the courts. We do ask that the court reverse the ALJ's final decision and declare that the CNOT provisions are unlawful and direct that they be stricken from the permits. Or at a minimum, remand the permits to EPD with instructions to substitute language that all DeKalb has to do is monitor and report what it is doing to the agency. But we think the clear answer here is that they're unlawful and they need to be stricken. And then lastly, we ask that the court consider the agency record request regulations and compel EPD to supplement, well, one, to rule on the legal question, and then two, if the court determines in DeKalb's favor that we are correct in our reading of the agency record request and the OSA regulations, that they be compelled to provide the additional documents. So with that, Your Honor, I am going to stop sharing and ask if the court has any other questions. I've gone on for a while. I thank you very much for hearing us, and happy to answer any questions.
I do have a couple of questions, and it's mostly about that last part you were talking about in terms of the result, the outcome that's being sought, right? Obviously, the larger procedural is that you want me to reverse the ALJ's decision. So my first question is, typically, what happens if I reverse the ALJ's decision, right? And it sounds like there's a possibility and I guess part of my question is there a possibility or a necessity of remand to the ALJ if in fact I'm going to reverse any or all of it? That's my first question. And my second question is, you talked about staying the permits. And I think I'm a little confused by that because my understanding is that in order to operate, y'all require the permits. It's just that there's a part of it that you object to. There's some the provisions that y'all are calling end result limitations are limiting your ability to implement the permit. Am I understanding that correctly? And or am I unnecessarily limiting what you're requesting?
I'll start in reverse order, Your Honor. No, you are properly understanding. The stay we are asking for would only apply to those CNOT provisions. And yes,
Okay.
we do want to operate under the permit more broadly. It's only the challenge provisions that we're seeking relief under. And then secondly, we don't think there needs to be a remand if you reverse on a legal ground. If you reverse on a factual ground on the reasonable or necessary aspect that is not outcome determinative, I guess there's a possibility of a remand there. Or if you were to find that there were something less than what EPD is doing. So, for example, a monitoring requirement, I think that is something that EPD would have to impose. So you could strike it and remand for further consideration as to whether monitoring only was something EPD wanted to do or not.
Okay. And then I guess my last question regarding the records dispute, right? And that was part of why I asked about the nature of a possible remand. Is it correct that, well, I don't think I want to ask, is it correct? I guess more is my question is that if I address this issue from a legal perspective, right? And say I were to rule in your favor and reverse the ALJ's decision, but not require any remand and merely stay those provisions as you've requested, through the appellate process. Let's say, for example, I were to do that. There's no basis or authority for me to order the EPD to produce anything else, right? That would be within the purview of the ALJ, would it not?
I think that if the court determined that there was a required production that was not made, the Administrative Procedure Act does permit us to move to supplement the record. But I'm
Well,
trying to think
I
through
certainly, forgive me for interrupting, certainly you're entitled to supplement the administrative record, but the nature of what you're seeking in terms of additional documentation would absolutely go to the underlying factual information that this court is not authorized to make judgments about, and certainly a subsequent appellate court would not be authorized to make judgments about. And so just from a procedural perspective, I guess my point is the relief on in terms of production of additional documents is only really necessary or appropriate, I think, unless you're going to persuade me differently. If the court somehow remands it back to the ALJ for something, then it would be potentially appropriate to say, hey, EPD, give them these documents so that y'all can all talk about what they mean, and the ALJ can make a decision about that factual evidence.
I understand what you're saying, Your Honor. My first point would be if the court reverses on legal grounds, then you would not need to reach the reasonable and necessary factual grounds. And so therefore, you would not need to remand on that basis. But if the court finds that further records were required, and if the court were to find that those might have influenced the ALJ's decision in the first instance, then I think you could remand for purposes of a production to the ALJ for them to, for her to consider whether or not that would change anything that she previously did.
Okay. Thank you, Mr. Droz. I appreciate that.
Yes, ma'am.
Mr. Held, am I going to be hearing from you?
Yes, Your Honor.
Okay. Can I ask you a favor? I have exceeded my cup of coffee and would like to go get another one. So before I hear from you, if you don't mind giving me just about a 5-minute break to get more coffee, does that work for you?
All right. We're off the record. I do appreciate that because I needed to go to the restroom real quick.
Yes, ma'am. It's 10:15. We're going to be on a break for 5-10 minutes. So if we'll all just target being back by 10:25.
All right.
Yes, ma'am. Thank you.
Thank you, Your Honor.
Thank you all. Madam Court Reporter, you ready to go back on the record?
Yes, ma'am, I am. All right,
Okay.
we're back on the record at 10:27.
Yes, ma'am. Mr. Held, you may proceed.
Thank you, Your Honor. So as you know, this case comes from DeKalb's challenge to the CNOT provisions in its two MPDES permits. The ALJ correctly upheld those provisions because they're best management practices that are reasonably necessary to further the purposes of the Clean Water Act, and they're authorized by law. So as you sort of laid out at the outset, this, as with most environmental law cases, the record here has a lot of overlapping state and federal statutes. It's got scientific and technical information, a lot of acronyms. But really, if you can distill this case down to its essential elements, this one is actually a fairly simple case. And I'm going to try to do that with you, but certainly to the extent I'm referencing something that you'd like me to explain more, or if there's some factual background that has skipped through Mr. Droz and my fingers, please don't hesitate to interrupt me and I'll do my best to fill that in. So the key points for this case, the record demonstrates that Georgia's lakes, and Lake Jackson in particular, are currently suffering problems with nutrient pollution. DeKalb discharges nutrients. DeKalb discharges nutrients into the South River, which is one of the tributaries for Lake Jackson. In fact, the record evidence shows that it is what's called an effluent-dominated river, which means that the majority of the flow of the South River is DeKalb's discharges, and it's one of the feeder rivers for Lake Jackson. EPD included these CNOT provisions in DeKalb's permits so that the current existing problems with nutrient pollution can be addressed now, while some longer-term, more targeted and rigid regulatory solutions to the nutrient pollution problem go into place.
Mr. Held, forgive me for interrupting, but I'd like for you to go back. I just want to clarify something you said a moment ago. You used a phrase, affluent dominated, and I think you indicated that that what that term means, at least what I understood you to say, is that DeKalb is the primary contributor to what is going into the South River.
That's right, Your Honor. The majority of the South River would exist even if DeKalb's facilities weren't there.
Sure.
But the majority of the existing flow of the South River as it's constituted today comes from DeKalb County's wastewater discharges.
Okay, and so the reason I wanted to flag that and ask you to clarify is that something that I heard from Mr. Droz a couple of times is that part of their issue is there's been no review to determine the extent to which DeKalb is contributing to the issue at Lake Jackson. And so am I remembering correctly that South is one of 4 rivers that are going into Lake Jackson?
That's right, Your Honor.
Okay, and so your position is that the record indicates that DeKalb is primarily, solely, majority, whatever phrase we're going to use, responsible for the South River, but we don't necessarily have any information about the other rivers and the relative contributions of the South relative to the other rivers going into that lake. Is that right?
That's correct. And I want to be very clear about what I'm saying, and I'll get in later to explaining why DeKalb's discharges are important for the nutrient contribution.
Mm-hmm.
But when I say that DeKalb is the majority of the flow of the South River, I'm speaking specifically about water. I'm not talking necessarily about nutrients. I mean, it would.
Well, I mean, it all goes
track
together, right? I mean,
right. Yes,
okay.
But I don't want to be accused of misstating something down the road. When I'm talking about it's the majority of the flow, I'm talking about the majority of the water in the river comes out of DeKalb's facilities. So
okay.
For the South River. And then there are the other tributaries as well, and they all come together in Lake Jackson.
Okay. But beyond that, Mr. Droz is correct that no specific review has been done to determine the extent to which DeKalb County's flow coming out of Snapfinger and Polebridge are specifically contributing to the chlorophyll levels at Lake Jackson that EPD is targeting for reduction. Is that correct?
That is currently correct, Your Honor. And now a moment ago, I mentioned sort of years-long processes that are going into place now. Mm-hmm. And that's part of that. That is something that is happening now, or the process is underway. And that's why these CNOT provisions are so important. is because we have a problem today, but to get the processes that you were just sort of describing correct, you have to do the science, you have to do the modeling, you have to do the sampling, you have to really make sure you correctly understand what's happening. And that can't be done overnight. And so when you have a problem today, it would be unreasonable to just let it fester for years and do nothing, knowing you have a problem while you wait for these processes to play out. And the ALJ correctly recognized all of these factors and relied on them in her decision, which is why she should be affirmed. Before I sort of dive into the specifics of the argument, though, I do want to just touch briefly on the standard review and burden of proof, and I won't belabor it because I know I heard you at the beginning to say that you
that's
are
the one
familiar.
part I'm pretty
I
familiar
know.
with, but
I just want to, so the two things I want to note, just because of the briefing, with regard to the factual findings, the ALJ made 18 factual findings in her final decision. And as you are aware, those are subject to any evidence standard of review, which DeKalb acknowledges in the standard review section of their brief. But a few times throughout the briefing, DeKalb talks about whether they say there's no substantial evidence that this, there's no substantial evidence that that. And I just want to be clear that that is not the standard. It's an any evidence standard on factual findings. And similarly, I want to talk about with burden of proof. There are a few times throughout the briefing that DeKalb has said EPD didn't show this, EPD didn't show that. But DeKalb had the burden of proof below, and they have the burden of proof here. So there was no required showing from EPD. DeKalb had the burden, and it couldn't meet that burden. So that's all I'll say about that. Before I get into specific arguments, though, the one other thing I think that is crucially important is we have to understand what the CNOT provisions are to understand the challenges against them. And so what the CNOT provisions are, they're provisions that are put into the permits of dischargers who discharge into rivers upstream of lakes. And the reason for that is the effects of nutrient pollution are felt most acutely in lakes and still water bodies, lakes and estuaries. They don't really have effect in flowing waters. It's when they all kind of stop and can accumulate that you have problems. And so it's not the South River, it's not the rivers, it's the lakes where you have issues. But the nutrients get there from the rivers. And so permittees upstream get CNOT provisions so that we can stop the effects downstream in the rivers. The CNOT provisions require permittees to come up with a plan. That plan has four required elements. You have to identify and quantify the sources of nutrients. So you have to figure out what's coming into your system. You have to evaluate potential source reductions. So you have to figure out if there's a way you can have less stuff coming into your system. You have to identify and implement operational adjustments aimed at reducing nutrients. So see if there's a way that you can have less stuff coming out of your system and give it a try. And now this is the one that Mr. Droz took issue with. He said that we're reading out a requirement that they implement reductions. That's not right.
Okay.
The requirement, the explicit language of the CNOT provision, I have it pulled up. It is identify and implement operational adjustments aimed to reduce nutrients. So it doesn't say reduce it. It says do things aimed to reduce it. It's aspirational, explicitly aspirational. And then the fourth element is establish site-specific nutrient reduction goals. So again, goals, not limits, not caps, not mandatory reductions, but goals. So it's an explicitly aspirational plan in those elements. Apart from those minimum criteria that go into the plan, the provision also requires annual reporting and reevaluation of the permittee's plans to look for things that they could do better. This recognizes the dynamic approach that goes into these plans. And it means that if a permittee submits a plan, it has all four required elements, they do what's in their plan, they give it a try, they have now complied with their permit, I guess, and they file reports saying whether they succeeded or not.
And that's that piece of paper Mr. Droz referenced that EPD's position is all they got to do is file a piece of paper and they're in compliance with the plan.
Right. You have to make a plan. It is more complicated than that, right? You have to make a plan. The plan has to meet the four required elements. It can't just be a piece of paper, right? and you do have to do what's in the plan. You have to implement your operational adjustments and aimed at reducing nutrients. You don't have to succeed in reducing nutrients. You have to try. And there's testimony throughout the record that these operational adjustments, they can be purchasing a new technology or purchasing additional chemicals. I think those are the examples Mr. Droz gave. But they can also be much lower cost, lower burden things like doing an annual nutrient audit, doing a sort of annual evaluation of your system. There are lots and lots of ways to comply. There's no one way, and that's the whole point of the CNOP. It puts the permittees in the driver's seat and takes a flexible, dynamic approach that lets each permittee tailor their plan to their individual financial abilities, their individual sort of technical abilities. It recognizes some permittees are going to have more ability to do more work. They're going to have more financial ability. They may have more room for improvement or less room for improvement. It recognizes they may try something that doesn't work, and it gives them the grace through that sort of annual reevaluation process
But
to.
forgive me for interrupting. Sorry, Mr. Held. So a couple of questions. One, isn't that what the RPA would do also?
That is not what the RPA would do.
Okay.
And so the RPA is a process specifically and only designed for implementing effluent limitations.
Mhm.
And so the way that an RPA works, so all water bodies are subject to what's called water quality standards.
Sure.
And so if there's a regulated standard of different pollutants that can be in the water body. And so what an RPA does is it looks at individual discharges and their discharges and determines whether you have the reasonable potential to cause or to contribute to an exceedance of that water quality standard. So is your discharge as a permittee, does it have a reasonable potential to end up being part of a violation of a water quality standard?
Mhm.
And then if so, you have to have an effluent limit. And as part of that analysis, it looks at your individual discharge, it looks at your controls, your sort of technology that's in place. It looks at
The point you're making now is sort of exactly why I asked the question, because what I'm hearing, part of Mr. Droz's complaint and what I was hearing you rebut is that there are fixes to this that are perhaps simple, perhaps less expensive. And what that sounds to me like is that there's some effort by both sides to argue that there should be some cost benefit analysis that's based on the likelihood of responsibility for contribution that would be determined in an RPA, right? An RPA would look at, is DeKalb a 10% contributor or is DeKalb a 90% contributor? And if I expect, and this is where I'd like for you to correct me if I'm wrong, if an RPA demonstrated that DeKalb was a 90% contributor, I can imagine that it would be reasonable for costly, substantial requirements and limitations to be placed on DeKalb County, as opposed to if they were found to be, say, a 5 or 10% contributor. And so I guess my question is, I keep hearing language from both sides that sounds a lot like a sort of cost benefit assessment. Where does that fit with either the RPA that I believe I understand that DeKalb County argues should have been ordered before it was essentially given a currently non-numeric effluent limit, I think is what I understand.
that is their position, yes.
Right. Versus y'all's position that it's not a non-numeric effluent limit, therefore no RPA is required. And yet you're still talking about essentially a cost benefit analysis. And that's where I'm getting a little off track.
So here's the difference, Your Honor. I think most fundamentally, with an RPA, I think you're correct in that it is sort of based on an apportionment of responsibility to some degree, but there's not really a cost benefit analysis. An essential part of an RPA is you do end up with a limit. It can be numeric, it can be non-numeric, but you end up with a limit. And there's no cost benefit, your limit is your limit, and you are forced to comply with it. You must comply, or you have violated the Clean Water Act. You're subject to enforcement. You're subject to citizen suits. Subject to very high liability.
No permit
Right?
shield. Right.
Right. And it doesn't really matter for purposes of the Clean Water Act if you can comply with your limit for free, or if you have to spend hundreds of millions of dollars to comply with your limit. You have to comply with your limit no matter what. That's not true of the CNOP. It's true that you have to comply with the CNOP provision, but the CNOP provision gives you the flexibility in your actual mechanisms of what you're going to try to say, well, we could do this and we might get more reductions, but we can't afford that, or we're not sure if that's worth it.
It
So
allows
you
the
do have
permit
that cost benefit.
operator to have an internal cost benefit. That, I mean, your position is that it allows the permit holder or the operator under the permit to have to do its own internal cost benefit analysis about what it might try to get to demonstrate its efforts to comply with the CNOP. Is that
Exactly?
okay?
Exactly.
Okay.
And so when you, as the permittee with a CNOP provision, you have all of the flexibility. You're in the driver's seat. You look at what you can do, what you can't do, what you can afford to do, what you can't afford to do. You make all those cost benefit analyses, and you come up with your plan. And as long as your plan meets those 4 requirements, most of which are sort of data collection, and then you have something that you're going to try to reduce your nutrients. You give it a try. You have complied with your permit. If you set a goal and you miss your goal, that's unfortunate, but it's not a permit violation. That's the key distinction here. If DeKalb sets a goal under their CNOP provision and they try to meet it, but they fail, they got the science wrong behind it, or there's some unforeseen factor, whatever. They say, we were going to discharge X, or we wanted to discharge X. Turns out we unfortunately discharge X plus 7. That's not a permit violation. If it were an effluent limit, that would 100% be a permit violation. So that's the key distinction here. And the reason that the CNOP allows for this flexibility is because it's using what's referred to as a watershed approach. Because I understand DeKalb sort of, they bristle at the idea of, well, if we can fail, then what's the point? But the point is that these provisions are going into the whole watershed, all the different permittees in the watershed. And different permittees are going to have different abilities. They're going to have different financial capabilities. They're going to have different technological capabilities. Some are going to try things that work. Some are going to try things that fail. But if everybody in the watershed is working in good faith, then on balance, things should improve. And so that's the concept that allows for this flexibility. So I've talked about what the CNOP provisions do, but just as important is what they don't do. And I've hit on this a little bit already in answer to your question, but the most important thing is they don't set a restriction. They don't set a particular reduction. They don't say you may discharge no more than X. They don't say you must reduce your discharges by Y%. There's none of that. The CAB has to set a goal, but they don't have to achieve that goal. They just have to try. It doesn't require that a particular technology or process be implemented. It doesn't say, you must install a nutrient optimizer. That's not a thing, but you understand my point. It doesn't require that they go purchase a certain thing. They're welcome to if they think that that's going to be helpful, but they don't have to. It's up to them. They're in the driver's seat. It doesn't require them to succeed in meeting their goals. You have to set the goals. You have to try. You don't have to succeed. And the most important thing is that this is not a final solution. We talked about this a moment ago, but the RPA process and effluent limits, that all is coming.
And
but those processes,
forgive me, just factually, I understand it.
Mhm.
It's not my purview to revisit those facts necessarily, but is the reason that this is all still in process because that designation about Lake Jackson only arose last year? Is that why?
That's not entirely it.
Okay.
So a couple things. First, there actually was an RPA conducted for phosphorus.
Mm-hmm.
DeKalb has a numeric effluent limit for phosphorus.
Mm-hmm.
And it's in the permit. It's unchallenged. It specifically refers to the effects of phosphorus on Lake Jackson. So there is an RPA for nutrients. What there isn't is an RPA for all nutrients. And so nitrogen is the one that's kind of the important one here. And the factual thing that's happened is sort of the understanding, and this starts to get pretty in the weeds, but the high level thing is, so the danger of nutrients, the point's taken that they're naturally occurring. Some level of them is important because they feed plants. But when they get out of control, plants can get out of control. You've heard of algal blooms in the news and stuff, I'm sure.
Right.
And the issue is when there's too many nutrients.
Forgive me for, I'm going to save you some trouble because I have read Judge
Okay.
Howell's opinion, and as a factual matter, she goes into some discussion in a few paragraphs and I think a footnote about the risk of those nutrients and what happens and why the EPD is concerned about them.
Right.
And so I think you've actually answered my question in terms of, I was just curious if there's a mention in some of the papers that the designation of Lake Jackson and the concern about it, about the chlorophyll A level, only arose in 2024. And so I was really just wondering if that was some of the cause of the delay, is because at the time that DeKalb is working out its permit and structure and how it's going to operate, all of a sudden this new issue of Lake Jackson arose that the parties are now trying to sort of reverse engineer how to deal with it.
That's partially true and partially,
Okay.
or partially correct and partially incorrect.
Okay.
So EPD already, if you go back years, was working on a nutrient management strategy, a statewide nutrient roadmap, because sort of broadly, the scientific community has realized that nutrients are more of a risk than we realized previously. I don't know why I said we. I'm not part of the scientific community. They have realized.
I firmly also am not. So
I'm a political science major, not a science major.
Same, sir.
So they have realized that it's more of a problem than they realized. And particularly, and this is where the issue here comes into play, there's a understanding the relative importance of phosphorus and nitrogen. The understanding of which one kind of drives things in lakes has changed more recently, which is part of why there's some existing processes for phosphorus and they're working on processes for nitrogen. So that's part of it. And that is a thing that's kind of been ongoing. There's, if you read through the briefing there, or maybe not in the briefing, but I think in the opinion, there's reference to EPA memos telling states you need to get serious about nutrient pollution. So that's a process that's been ongoing for years. Now, you layer on top of that the listing of Lake Jackson. And so Lake Jackson is not meeting its chlorophyll level. There's a regulated, safe level of chlorophyll, and Lake Jackson is above that. Which takes me to something that Mr. Droz said. You know, he talked about the naturally occurring things should not be regulated at the same level of toxins. Well, they're not, right? That's built into the water quality standards. And so when we say that Lake Jackson is exceeding its level for chlorophyll, that's the level that's been determined to be safe for chlorophyll, which is a different level than what's been determined to be safe for certain toxins or for bacteria or whatever, right? Everything is kind of built in based on its risk, whether it's acute risk, chronic risk, whatever. So that difference between a toxin and chlorophyll is already built into the standards. And with Lake Jackson, it's not meeting its level for chlorophyll. So those levels are unsafe per the regulations today. And so once that happens, a bunch of processes come into place, one of which is the development of what's called a total maximum daily load, or TMDL. And that is the piece that comes in and starts apportioning at the total maximum daily load is talking about the total amount of a pollutant that can safely be in a water body. And then it apportions that amongst all of the sources of that pollutant. And that is not something you can just slap together overnight, right? You have to look at the particular water body, look at what can go into it, look at all the sources, build it out backwards from there to apportion the relative loads. And then that, in turn, becomes part of how you develop effluent limits. And so there's the years-long sort of just getting more serious about nutrients that's already been going on. But then with Lake Jackson's specific listing, we now have this specific process directed only at Lake Jackson that is kicked into place of developing a TMDL and apportioning the nutrient load. Because an important thing with chlorophyll, nobody really discharges chlorophyll, right? Algae discharge chlorophyll. We don't permit them.
Again, you're taking me back to
Yeah,
college level bio class that I've tried really hard to forget.
and I'm sorry about that, Your Honor.
That's no problem.
But plants produce chlorophyll. It's how they get their food. DeKalb doesn't discharge chlorophyll, but what DeKalb discharges is nutrients that the algae eat. And so to have a lot of chlorophyll, you have to have a lot of algae. To have a lot of algae, you have to have a lot of nutrients from them to eat. And that's why chlorophyll is relevant for nutrients. It's the product of the plants. The plants have to have the food. And so because nobody really discharges chlorophyll, if you have a chlorophyll problem, if we had a bacteria problem, right? People discharge bacteria. And so the way you fix a bacteria problem is you dial back discharges of bacteria. Here, where we have a chlorophyll problem, but nobody discharges chlorophyll, you have to dial back the nutrient discharges. And so that's how that all ties back to DeKalb's discharges, because
Right.
that's the thing that we can control. So that takes a while to develop, to correctly apportion that load, and that's going to go into people's permit. I mean, that's going to affect people's permit limits. It's going to affect their substantial rights. And so it's important that that process be done correctly. And that's going to take some time. And so the CNOT provision is an interim measure so that we know we have a problem today. It doesn't work to wait years while that process plays out and just do nothing, hoping the problem's going to fix itself. The CNOT fills that gap. So the fundamental issue is whether the CNOT provisions in filling that gap have become effluent limits, and they're not. And we know that it's not just a matter of labels. Mr. Joe said you can't just call it a BMP and make it a BMP. That's correct. It's not just a matter of labels. It's a matter of regulatory definitions, right? We have codified definitions of these things. And the codified definition in state and federal law of an effluent limit is that an effluent limit is a restriction on a quantity, concentration, or rate of a discharge. That's in the state law. It's also in the CFR. The CNOT provisions are not a restriction on a quantity, a concentration, or a rate of a discharge. It doesn't, DeKalb points out that they can be non-numeric, there's non-numeric effluent limits. That's true. They point out in the briefing that something can be a best management practice and an effluent limit. That's true. But no matter what type of effluent limit something is, to be any type of effluent limit, it still must meet that definition of a restriction on a quantity, concentration, or rate of a discharge. The CNOT provisions don't do that. They require implementing practices aimed at reducing nutrients. They require setting goals. They require reevaluating those goals, but they do not actually restrict your discharges. EPA knows how to restrict discharges when it wants to, right? That's DeKalb's phosphorus limit. There's a set amount of phosphorus above which they cannot discharge. The CNOT provision requires a goal, something that you're trying not to discharge more than, but if you discharge more than your goal, you just have to report that and you've not violated your permit. So therefore, because it's not a restriction, it cannot be an effluent limit as a matter of law. The ALJ correctly recognized all this in her summary determination order. I think of it sort of the difference between paying off a loan or saving for retirement, right? They're both long-term financial commitments. Paying off a loan, you have some minimum payment. And if you don't make your minimum payment, the bank's going to penalize you. It's going to charge you interest. It's going to repossess your car. Saving for retirement, also a long-term financial goal, but it's more dynamic. You have where you want to be. You look at where you are. You kind of track it. You think things aren't going quite as well. Maybe I'm going to contribute some more, or maybe I'm going to push my retirement date. Things are going better than I thought. Maybe I'll free up some cash. But it's dynamic and there's no penalties associated with it. You just kind of track it over time. That's the difference we have here. Effluent limits are like that loan payment. Maybe you can try to do better, but if you don't do what you're required to do, there's a penalty. The CNOT provisions don't have that. If you set a goal and you miss your goal, you reassess. You see if there's a way you can meet that goal next year, or you see if your goal needs to change. Maybe your goal is unrealistic. Mr. Joes points out that you have to annually set new goals. It doesn't say you have to set more stringent goals, right? You have to just reassess, reevaluate, and set a new goal. And so you can come in and say, our goal was not realistic. We know that now. That's something that's allowable because it's a dynamic process that leaves the permittee in the driver's seat. So if you look at the language of the CNOT provision, which I encourage you to do, to just read its explicit terms, you'll see that all of the actual requirements as far as the cab's performance are aspirational. Aim to reduce nutrients, set goals, set targets. They're not restrictions on quantities, concentrations, or rates of discharges. Therefore, they cannot be effluent limits.
So I think a moment ago you read off to me, Mr. Droz had pointed out that it said that the DeKalb County was required to, quote, implement reductions. And you read off to me the language that I think, and I'm not saying it exactly, but I think you said that that's actually not what it says. What it says is some variation of implement procedures or protections or whatever those things are called that would be designed to reduce, something along those lines. Is that right?
That's right, Your Honor. It's identifying. No, that's not it. It's identify and implement operational adjustments aimed to reduce nutrients.
Okay, thank you.
Of course. So because these are not restrictions on quantities, concentrations, or rates of discharges, they're not effluent limits. And if they're not effluent limits, then all of the arguments about reasonable potential analyses go out the window. Because a reasonable potential analysis, we talked about this earlier, but that is a process only for developing effluent limits. So if these aren't effluent limits, there's no requirement to do an RPA. That process only attaches to effluent limits. It comes from 40 CFR 122.44D, that's the RPA. Separate from D, paragraph K, 122.44K, is where best management practices are authorized. And so the folks drafting 122.44 knew how to require an RPA. They did require it for effluent limits. They did not put that requirement in paragraph K for best management practices. So we know that it's not required for best management practices, only effluent limits. Because the CNOT provisions are not effluent limits, no RPA was required. There's, Mr. Droz mentioned testimony from Ms. Fenwick saying that an RPA should have been conducted. That was not testimony related to the CNOT provision. And I mean, we go into this in our briefing, and I, encourage you to look at the sites and see what she said, because she was asked sort of as a matter of permitting policy, are you supposed to conduct an RPA for all pollutants of concern? She said yes. And EPD did conduct an RPA for phosphorus. It doesn't have a process for doing an RPA for nitrogen. It's working on that. So it would have been unfair to apply an RPA with no process. But the result of that is EPD was precluded from imposing an effluent limit for nitrogen. But they didn't do that. So there's no harm in that. The CNOT provisions are entirely apart from this RPA effluent limits process. They're best management practices. And as Ms. Fenwick explicitly testified, there is no, and correctly testified, because it's not just her opinion, it's the law, the RPA process isn't required for best management practices. So that sort of takes me to gives away the next point. The CNOT provisions are best management practices. And we know this because best management practices is defined in the Code of Federal Regulations as management practices to prevent or reduce the pollution of waters of the United States. So practices to reduce pollution, that's exactly what we have here.
Right, but so I think if I, just devil's advocate for a moment, if Mr. Droz was allowed to directly respond to that, I think the argument I heard from him is that's a pretty vague definition. And that means that you could that anything that you did, including a specific numeric effluent limit that hadn't gone through the appropriate process to be designated as a rule could be labeled as a best management practice under that really vague definition.
So
Really vague. It is a definition. Go ahead.
Well, that's exactly the point, Your Honor. That is just a general definition. And then that definition is applied through 4 specific authorizations for best management practices. 3 of them are entirely irrelevant here. So what we're really talking about, and this all comes from 40 CFR 122.44K. That's what authorizes best management practices. And K4 says that you can have best management practices that are reasonably necessary to achieve effluent limits and standards or to carry out the purposes of the Clean Water Act. So there's 2 important takeaways from that regulatory language. First, it tells us that best management practices can be unrelated to effluent limits or water quality standards, because it says to achieve effluent limits and standards or to carry out the purposes of the Clean Water Act. And second, it says reasonably necessary. It could say necessary, could say absolutely necessary. It could say reasonable and necessary, but it says reasonably necessary. Reasonably modifies necessary. It tempers that standard. And I know that I personally have fallen into the trap of sometimes talking about why the CNOT provisions are reasonable and talking about why they're necessary, because they are reasonable and they are necessary. But as a matter of law, the standard is reasonably necessary. And so that's important when we are talking about these provisions. And so why are they reasonably necessary in this case? The simple answer is because Lake Jackson has a nutrient problem, and these are provisions designed to reduce nutrients going into that lake in this particular instance. It's not the only lake with problems. It's not the only discharger who has a CNOT provision. But in this instance, we've got a lake with a problem, and this is something designed to mitigate that problem. But to sort of dig in more specifically on the ALJ's factual findings, there are sort of 5 important points that I think make the logical train to get us to reasonably necessary. So first, and I know we have some of this already in the discussion today, but to kind of lay it out in sequence. First, DeKalb discharges nutrients into the South River, and the South River feeds Lake Jackson. That's all uncontested. That's factual findings 1, 2, and 14. Second, when a lake has too many nutrients, it can lead to an excessive growth of algae, which can deplete oxygen and kill all the aquatic life in the water body. And a measure of the amount of algae in a water body is chlorophyll A. It's something that can be tested for and measured. And it's an indicator because algae make the chlorophyll, algae eat the nutrients. And so if there's a lot of chlorophyll, there's a lot of nutrients. That's uncontested amongst the expert witnesses and is found in factual findings 3 and 9. Third, under the Clean Water Act, you have the health of water bodies measured by water quality standards. And when a water body isn't meeting its water quality standard for a particular pollutant, it becomes impaired. That's the term that's used. And it goes on a list that the state prepares and sends to EPA. Lake Jackson, which is fed by South River, which has DeKalb's discharges, was listed in 2024 as impaired for chlorophyll A. So this specific lake has a problem for chlorophyll as of last year. And again, chlorophyll is a measure of nutrients. So that all comes from factual finding 11. Fourth thing in the logic chain is when a water body is listed, there's certain processes that kick into play. That's the total maximum daily load I referenced earlier. That's reasonable potential analyses to, set effluent limits for different dischargers to fix the impairment. But those processes can take years to address the problem. And so we have a problem now, but the default processes that kick into place because of that listing can take a long time to implement. That comes from factual findings 12 and 13. And so then the key one is the fifth thing. The CNOT provisions are included in the permits to fill that gap in time so we can do something now while these other processes play out. That's factual finding 15. And It's not as stringent as an effluent limit because you have that flexibility. That's why it is reasonable to put each discharger sort of in the driver's seat to see what they can do so that their efforts in the aggregate can make things better. And it doesn't require reductions, doesn't require you to succeed in what you're trying, but it does require you to try, because it's sort of like saying, if you had a really bad cut, that there's no sense in sort of trying to staunch the bleeding on the way to the hospital because, well, this really requires stitches. No, you're going to put a towel on it, because even though the stitches are what you ultimately need, you got to do something now. And it's the same sort of thing. Ultimately, we need RPAs, we need effluent limits, we need TMDLs, but that takes a while. And so we have to do something now to try to make things better, even if it's not a final solution. So I want to kind of hit three final points that I have on the CNOPS and the reasonable potential analysis and all that before I move on to some of the ancillary arguments. So first, the CAB talks about the weight that the ALJ gave to certain witness testimony. As you're aware, she was the finder of fact, and her findings are supported in her decision with citations to the record that do in fact support what she concluded. And so the weight that she gave to different individual experts is entitled to any evidence standard of review. Second, the CAB talks a lot about site-specific evidence. That's not a standard in K4, 12244 K4. That is a standard that is applied elsewhere in the Clean Water Act. But it's not actually a codified standard here of site-specific evidence. However, even though that's not the governing standard, it is a standard that we satisfy here because there is site-specific evidence. The CAB discharges nutrients. Not everybody does. That's site-specific evidence. They discharge them into a river upstream of a lake. Not everybody does. That's site-specific evidence. That particular lake suffers from a chlorophyll impairment. Not every lake does. That's site-specific evidence. So the CAB says there's no site-specific evidence in the record. What they mean is there's not the site-specific evidence that they'd like to see, but that does not mean that the record is devoid of any site-specific evidence. So even if that were the standard that applied, which it's not, the point is this is a site-specific case for DeKalb. This provision went into other permits for other lakes as well, but it's supported here by these specific facts. And then the last thing that I wasn't going to get into, but because Mr. Drew spent some time on it, I just want to briefly touch on San Francisco, that recent Supreme Court case. Mm-hmm. When Your Honor was talking about it with Mr. Drew, I think you were saying a lot of the things that I was going to say. I would encourage, if that's something that's giving you pause, the majority opinions are only 20 pages.
Which is remarkably short for a Supreme Court opinion these days.
That's why I call attention to it. So, but that said, that was a dramatically different case. I would argue that's actually the polar opposite of what we have here, because the provisions that were challenged in San Francisco, those were non-numeric effluent limits explicitly. That wasn't.
And they were clearly result-based, and that also arguably were so vague as to be, the question is whether San Francisco could figure out how to enforce them and had the ability to control to lead to the result that was sought in those two limitations. Exactly.
And so those provisions said, don't cause a water quality problem downstream. And downstream, I believe downstream of one of the facilities is the Pacific Ocean. So don't cause a water quality problem in the Pacific Ocean. And if you do, and this is the important part, and if you do, you have violated your effluent limit and you're subject to liability, right? If we told the CAB, don't cause a problem in Lake Jackson, figure out how you want to not cause a problem, but just don't cause a problem, that would be on par with San Francisco. That's not what happened here. EPD said there is a problem. We're asking you to try to do things that make the world better. But as long as you're trying, we're not going to subject you to liability on what ends up happening, right? That's what the Supreme Court took issue with, that San Francisco suffered liability based on the end result over which they didn't have control. That's not the case here. The end result of DeKalb's CNOT plan is whether there's pollution in Lake Jackson, but that's not the measure of their success for permitting purposes and for liability purposes. The only thing that is required by the permit is that you make and implement your plan and that it meet the 4 factors, right? And if you've done that, you have complied with your permit. That is a very discrete, specific requirement. You have flexibility in how you fulfill it, but as a discrete requirement, it gives DeKalb the sort of certainty that the Supreme Court took issue with. DeKalb knows exactly what it has to do. It has to make a plan and has to implement that plan. It does not take things out of their control the way that the effluent limits in San Francisco did. So San Francisco was results-based. The CNOT provision doesn't actually care about the results per se. I mean, of course, that's the policy behind it.
Well, and that is really one of the questions I have. I mean, I agree with you, and I understand EPD's position that if the language is as it's been characterized, that it is not a requirement that they implement reductions. It is a requirement that they implement operational adjustments that are aimed to reduce those nutrients, right? So I agree with you. That's something that you could theoretically comply with, that a rise in the nutrient level or a non-decrease in the nutrient level wouldn't necessarily be a violation. But when you have DeKalb County's witness testifying that both of those sources, I don't exactly know what to call them.
The wastewater treatment facilities.
Yes, thank you. Snapfinger and Pole Bridge Creek, that both of them are already fully optimized. And I understand there's some factual dispute about whether or not additional efforts or additional study could be made to determine if there were other things that could be done to optimize. And clearly in paragraph 18, Judge, the ALJ, Howells made a factual finding on that point. But I guess, isn't there a universe in which if DeKalb finds that it's fully optimized and those numbers keep going up, that they could still be penalized for failing to make an operational adjustment aimed at reducing, right?
So a few things on that, Your Honor. First, almost nobody is doing everything that's possible, right? And so that's part of the thinking behind this, is that some permittees, earlier I mentioned the watershed approach. And so it's the idea that you sort of aggregate all the different permittees' attempts, and that those in the aggregate are going to have an effect on Lake Jackson. And so it recognizes that some facilities might be doing a really good job. And so the things that are sort of available to them to do better are going to be small. This allows for that. That's one of the differences between this and an effluent limit. This allows for something like implementing annual audits to make sure that you're staying on track. That is an operational. If you're not doing annual audits, adding annual audits in is an operational adjustment you could make to make sure you're sticking on track. So if you, in a world where you truly had somebody who is doing everything under the sun, their operational adjustment could be some additional level of oversight, right? Just to make sure that that continues to be true. In this particular instance, though, the testimony from Mr. Gobin showed that they hadn't actually looked at what they could do differently. With regard to Snapfinger, there was this recent expansion that Mr. Droz referenced. And of course that was permitted, and so EPD was involved in that process. But, now that it's coming online, there was testimony from both of DeKalb's witnesses, Mr. Gobin and Ms. Nomura, that they don't really know how it's going to perform, and so there may be room for improvement. And so that's those sort of things. The fact that they didn't really look into what they could do better, that's what led Judge Howells to sort of disregard that testimony or give it little weight, because the reality is there is stuff that DeKalb could be doing. But even in a world where a permittee is doing everything they can, they could still add some layer of, further, checks to make sure that continues to be true, that sort of thing. And, candidly, like that is not going to, those sorts of additional checks are not going to have dramatic effects on Lake Jackson. But that's why it's a watershed approach, because if you have somebody who's already doing great and they can only do a little, then that's wonderful. And it means that, they're sort of maxed out and other permittees may be able to pick up more of the slack. But that doesn't mean they can't do anything or that they're going to end up violating their permit. And certainly DeKalb is not in that position. So for all of those reasons, the CNOT provisions are effluent limits, or not effluent limits, they are BMPs. They're BMPs that are reasonably necessary, and the ALJ's factual findings support that, and she should be affirmed because the permits here are legal. Which then takes me just to briefly talk about the home rule argument. I'll primarily stand on our brief for that. But the key point there is the CAB's argument is essentially it violates their home rule rights to be subjected to an illegal permit. So if the permits are legal, if we win on the merits, then a necessary factual predicate for their claim fails, and you don't need to reach the home rule provision. If they're right and the permits are illegal, then we lose on the merits because the permits are illegal and you can't enact illegal permits, and so you don't need to reach the constitutional issue. So there's no situation in which you need to reach the constitutional issue. The permits are legal, and so it's not a violation of home rule. They're legal and authorized by the Clean Water Act, and so you don't need to get there. But if I'm wrong, if you rule against us and find that the permits are illegal, we lose on the statutory argument. You don't have to get into the Constitution. It's entirely superfluous.
Okay. A couple of questions, Tim. Oh, I'm sorry. I thought you were done. I apologize.
The last thing I was going to touch on was the agency records request. I can save that if you want to sort of keep on the CNOP itself, or I can do it now.
No, please go ahead.
Okay. So it's our position that it's OSA Rule 37, which OSA Rule 37 really just directs you to OCGA 501318D. And it's our position that provision is inapplicable to this sort of case, a permit challenge. And I'll explain why in a moment. But even if that's incorrect, even if that provision is applicable in this case, in this particular instance, DeKalb waived their only available remedy, and therefore their request became moot. And so there was no error resulting from their request. And this comes from the statutory language. And so if you permit me, I'll just read a couple things real quick. 501318D1 says, in contested cases which could result in the revocation, suspension, or limitation of a license, when a licensee makes a general or specific request for exculpatory, favorable, or arguably favorable information that is relative to pending allegations concerning a license, an agency must furnish the requested information, indicate that no such information exists, or refuse to furnish the information requested prior to a hearing.
Mr. Hill, forgive me for interrupting. Let me save you the trouble. So I have read the decision, and I am aware that where the ALJ came down is that those provisions that are being invoked for why they would be entitled to that documentation is when there is a contested case or when there's an investigation that then leads to a contested case. I understand what those provisions say, and I understand the ALJ's position on that. So you can save yourself the trouble on that one.
Sure. And so the only thing I'd add is the exclusive remedy is a pre-hearing investigation or a pre-hearing review of the investigative file. And it allows that the licensee may request that inspection. DeKalb never requested that inspection. And then once the hearing began, you can no longer have a pre-hearing inspection because pre-hearing is gone now. And so by not requesting that inspection, DeKalb waived their exclusive remedy. And by allowing the hearing to begin, when Judge Howell said that she was going to reserve ruling, DeKalb said that sounds fine. So they allowed the hearing to begin without objection. And so now pre-hearing no longer exists. So we support what the ALJ said about the applicability, but we also believe that DeKalb waived its exclusive remedy and that the request became moot. And so there's no error with regard to the Rule 37 request.
To that end, though, is there an investigative file, right? I mean, I understood the ALJ's decision to be there isn't an investigative file because there wasn't an investigation because that's not the nature of this dispute. And so whether somebody asked for it pre-hearing or waived it by not doing it pre-hearing is kind of irrelevant, isn't it? Because there was nothing for them to review.
Right. This provision doesn't apply in this case. This provision is the administrative equivalent of Brady, right?
Right.
So, Brady evidence in a criminal context, that's what this is. It's for if the board of nursing is going to take away a nurse's license because of some misconduct, that nurse has the sort of due process rights that a criminal defendant has under Brady. And that's codified in 5013-18D. That's what this is for. There's no investigative file in a permitting case. There's a permitting file. And DeKalb has most of the information in the permitting file because they're the permit applicant. Now, they say that there's some stuff that they wanted that's not in an investigative file, so it wouldn't be subject to this rule. And they have a right to that under the Open Records Act. They can request that separately. We have open government, we have open records. They can have whatever records they want, subject to privilege and all that, but not through this vehicle. And so there's no error with regard to this motion. So that's all I have, but I'm happy to answer any questions you have, Your Honor.
Well, mainly my question to you is similar to my last question to Mr. Droz, which is, I mean, obviously I understand that the EPD's position is that Judge Howells should be affirmed, right? That the decision was not clearly erroneous, that she didn't commit any errors of law, and that the decision wasn't arbitrary and capricious, and that her findings of fact are supported by some evidence. In terms of that ruling, and your position, so your desired outcome would be an affirmance of the decision that was made by Judge Howells, which would, other than the home rule issue, which is sort of outside that, it would not require, I mean, it doesn't require anything else really from this court in terms of deciding what to do or not do. And I guess really my question is, what if I affirm the ALJ, your position is that the court doesn't need to address the home rule issue?
Correct.
So let me back up for a moment. Regarding the issue of the request for documents, even though I understand your position, one of the questions I had for Mr. Droz was, let's say I'm interested in reversing the ALJ for some reason, and I'm going to send it back. Are you in agreement that if I order the production of any additional documentation, that it would have to come in at the ALJ level, and then the ALJ would have to have an opportunity to consider it and determine? Because while Mr. Droz said he's entitled to supplement his record, that's usually supplementing things that already existed in the lower court's file that somehow didn't make it into the appellate record, right?
Right. And so there is a provision, and we cited it in our brief, and I don't have it on hand, but there is a provision that the record, that you can make a motion on a petition for judicial review. I think this comes from 5013-19, to add additional information that was not contained in the record below. But you're exactly right that under those circumstances, that evidence is heard in the first instance by the ALJ, and she makes a determination of whether that would change the outcome of the case. And then it would be part of the record on a subsequent appeal to Your Honor.
Okay.
But there's no provision for you to be taking evidence in the first instance.
Okay.
So if you were to remand and to disagree with us on the Rule 37 request, then Judge Howells could consider that evidence in the first place. But
okay. The last question, I'm going to ask you to sort of revisit the home rule issue.
Okay.
Because I'm still not quite clear on how it is. It sounds a lot like heads, DeKalb County wins, tails, you lose. DeKalb County, I'm not using that cliche correctly, but you're following my point.
I do. And with all due respect, I think the way that you sort of misstated that cliche is exactly what it actually is, right? Because it's heads, DeKalb County wins, tails, EPD wins, right? It's binary. Because for DeKalb County to prevail on their home rule argument, for them to win their home rule argument is the state government cannot subject us to illegal permits. That's not a controversial position. We all agree on that. But what we disagree on is whether that in fact happened here, right? And so I fully agree that if the permit is illegal, then EPD loses because we can't issue legal permits. But we can't issue legal permits because that's not something EPD is authorized to do. That's why it's illegal. And so you don't have to reach a constitutional issue of the illegal permit violates constitutional rights. This is an appeal of a permit, and if the permit's illegal, the permit's illegal. EPD loses. On the flip side, and this is the actual case here, the permit is perfectly legal. It's authorized by the Clean Water Act and the Georgia Water Quality Control Act. And so in the world where DeKalb holds permits that are issued validly under state and federal authorization, those permits comply with the statutes. Those permits are authorized by law. They were procedurally proper. There's nothing wrong with the permit. There's no constitutional violation for a permittee having a permit. And so either the permit's illegal and we lose on the merits, regardless of the constitutional issue, or the permit's, I think I said that correctly, but I think you understand what I'm saying. Either the permit's illegal and we lose both on the merits and I guess on the constitutional issue, but you don't have to get there, or the permit is legal, which is the actual case here, and we win on the merits, and therefore a necessary factual predicate for their home rule argument is not there because we have a legal permit, not an illegal permit, and so you don't have to rule on the constitutional issue because factually their claim fails. Does that make sense, Your Honor?
It does. Thank you. Anything else you want to add, Mr. Held, before I let Mr. Droz have the last word because he's the movant?
Just that we believe that the ALJ's opinion is well-reasoned, is thoroughly explained through her factual findings and her citation to the evidence, is correct as a matter of law and should be affirmed on all counts.
Okay. Thank you, Mr. Held. Mr.
Thank you,
Droz?
Your Honor.
Thank you, Your Honor. I'd like to just sort of start, and I'm going to try and be brief and just hit a few of the high points, but I'd like to start with that CNOP language itself, because while I think, and I understand why Mr. Held wants to minimize the impact of that language, the language is the language. And it says, the CNOP shall, at a minimum, identify and quantify sources of nutrients entering the wastewater treatment plant, evaluate potential source reductions, identify and implement operational adjustments aimed to reduce nutrients, and establish annual nutrient reduction goals. So the language he tried to make this sound plain vanilla, aimed to reduce nutrients, modifies operational adjustments. And you're not making operational adjustments unless you're trying to reduce nutrients, and you're required under the plan to not only identify, but to implement operational adjustments. So to suggest that this is not a restriction on behavior ignores the explicit language itself. Otherwise, the word implement has no meaning. If the language just said you just have to identify operational adjustments aimed to reduce nutrients, what Mr. Held says might have some weight to it, but it doesn't. It's joined by the conjunctive of identify and implement. It is forcing DeKalb County to reduce those nutrient loads. And I think it's important here, Your Honor, and I'm gonna give you a case that's not in the materials, but it illustrates a point. It's the case of Hughey, Hughey versus Gwinnett County, 278 Georgia, 740, 2004. And in that case, what the Supreme Court said, I'll give you the background. Gwinnett County had built a shiny new wastewater treatment plant that discharged into Lake Lanier. And it could do more than its permit required. It could take more out of the water than its permit required. And the Supreme Court said, if you can, you must. Even though it's above the regulatory limit in your permit, you still have to do more. And as a result of that, and that's part of, and I won't go down this path, but there's some rules called anti-degradation rules that basically once you achieve a certain point, you can't go backwards. So what this CNOP does is say, okay, you keep ratcheting up, even if there's not a regulatory basis, because there's no RPA, there's no impaired stream, there's no analysis of the connection between DeKalb's contributions and Lake Jackson. From that point on, DeKalb County arguably is stuck with whatever it does, even if it wasn't required to do that in the first place. And so there is a danger that this sort of, oh, you're in the driver's seat, do what you want to do. That is not the way the Clean Water Act has been applied in Georgia. And the Huey case exemplifies that. And for the same reason, this issue of implementing operational adjustments shows exactly why it is, in fact, an effluent limit. We have to set a goal, we have to hit a goal, we have to continuously improve a goal. Now, the fact that EPA or EPD rather hasn't actually put it in the permit doesn't mean that we are not now self-regulating, which is what the Clean Water Act says you're not supposed to have to do. It's the regulator's job. And so I just want to give you, again, the court referenced San Francisco. Here's the question. Who bears the burden of the lack of available information? And Mr. Held argues, well, if you can do better, then do better. Well, that's not what the Supreme Court said in San Francisco, because that same argument was advanced by EPA. And I'll read from the decision. The EPA maintains that the imposition of end result limitations is the best course of action when the information necessary to develop additional effluent limitations is unavailable. And it complains that it should not bear the burden of determining what a permittee should do to protect water quality, because a permittee is likely to have better access to necessary information and a superior understanding of the operation of its facility and the changes that could be made to further protect water quality. Sound familiar? We are not moved by this argument. For one thing, it appears that the EPA and state permitting authorities have used end result requirements routinely, not just when a permit holder has failed to provide necessary information. And in any event, the EPA possesses the expertise, which it regularly touts in litigation, and the resources necessary to determine what a permittee should do. It is also armed with ample tools to deal with situations in which a permittee is slow to provide needed information or is otherwise uncooperative. The Supreme Court has given us the answer to that question. And that risk of lack of information does not fall on the permittee. It falls on the agency. And if the agency has priorities and it needs to use its existing resources to allocate it to one problem that's deemed more of a problem than others, then it can do that. If it thinks Lake Jackson is more important than any other lake in Georgia, it can allocate its resources. It can speed up the time within which it can do the scientific analysis, and it can reach an answer on that lake. But that is the regulator's burden in the first instance. It is not the permittee's burden. And this cookie cutter approach that we're just going to throw it out to everybody in the regulated community and do what you can at the risk of spending money unnecessarily and potentially being stuck with standards that you would not otherwise be held to because you weren't part of the problem. That's just not the way that the Clean Water Act was ever intended to operate. So, the suggestion again was made that, well, San Francisco didn't have control. Well, DeKalb doesn't have control over the other three water bodies that feed into Lake Jackson, and it doesn't have control with all of the other dischargers onto South River that feeds into Lake Jackson. We don't control any of that, and yet we're being told we have to implement operational adjustments that reduce nutrient loads. And I want to note, and I appreciate Mr. Held's clarification on his point that effluent dominated does not mean nutrient dominated. So I did not understand him to be saying that even though we were putting wastewater into South River, that it was his position that we were the primary nutrient contributor into the South River. And I
Right. And
think
that's
that's
why I
an,
asked for that clarification. So I
thank you.
appreciate that, Mr. Droz and Mr. Held.
Yes, I think that is an important point, and I appreciate Mr. Held's candor on that. So, we do think that this is an end result, based standard, and just the way San Francisco was told, don't cause a water quality problem in the Pacific Ocean, we're being told don't cause a water quality problem in Lake Jackson, without any science, without any indication whatsoever that our nutrients are the ones that are causing the problems in Lake Jackson. So we think this case is much more akin to San Francisco than was earlier suggested. Um, I did just want to point out quickly the RPAs are intended to do exactly what DeKalb is asking for here, which is understanding whether there is an impairment in the South River. Currently, it's not listed as impaired. They're talking about Lake Jackson as being impaired, not the South River where we discharge. And I think this is clear, but just to make sure, DeKalb County does not directly discharge to Lake Jackson. There are miles of downstream contributions completely independent of DeKalb County. So the RPA would give us that analysis. It would tell us what our specific targets are. And the whole purpose of an NPDES permit is to translate the goals, the intent and purpose of the CWA into a discharger's actual obligations. That is what the NPDES permit is intended to do. And so having those limits in there, which again in San Francisco, the court described as an invaluable right in terms of a permit shield, having those specifics in a permit are the way that you activate your permit shield protections and that you're not subject to additional liabilities beyond the enforcement activity of the agency itself. And I do find it, and I'm going to actually point out a part of the brief because I was actually a little bit stunned when I read it. Between page 14 and 15, EPD makes the statement that DeKalb initially attaches mistaken importance to the idea that the South River itself does not have nutrient criteria, and then goes on to say, and this is what I found a little bit amazing, regardless, this distinction is immaterial because the applicable water quality standard is irrelevant to EPD's authority to impose best management practices to further the purposes and intent of the Clean Water Act. And I just want that to sink in for a minute. The applicable water quality standard is irrelevant. That is the whole purpose of the regulation, is to assure that water quality is met. That statement there is a poster child for arbitrary and capricious action. There is no scientific basis for what EPD is trying to do to DeKalb County and requiring it to do in terms of actions that it must undertake under the CNOP. I understand. I spent 8.5 years at the Attorney General's office. I understand why you run to the cloak of the burden of proof and the clearly erroneous standard, but the clearly erroneous standard does not help you, and the any evidence standard does not help you when there is no evidence in the record. That is arbitrary and capricious. And there's no
Mr.
evidence in the record to show that DeKalb County directly contributes nutrients to the South River that cause a problem in Lake Jackson.
Well, and that's actually thank you for that helpful segue, because that was actually one of the issues I was going to ask about, to be specific. So I think one of the things that Mr. Held did was sort of rattle off the what he believed were the established facts in the record with specific references to the different paragraphs. And one of the things he characterized is that there's not really any dispute that DeKalb is discharging into the South River and that the South River ultimately leads to Lake Jackson. And I think I understand your distinction in terms of there not being, I mean, there's no need necessarily for evidence of those facts because those facts are agreed and established and no one disputes them. But I think I understand your point to be that what the record lacks in terms of any evidence that supports the legal decisions that were made by the ALJ is that DeKalb's discharge into the South River is contributing to the nutrient load in Lake Jackson. Is that correct?
That is correct, Your Honor.
Okay. And so is that really the primary basis for why you believe there's no, because I heard lots of things about there's no substantial evidence or the EPD didn't offer any evidence of this or that in your original argument. But in terms of there not being any evidence to support the various findings, that's one that I clearly understand your argument, right? That there's not any evidence on that point. Is that sort of the whole ballgame for you, that lacking such evidence, there's really no basis for the finding at all that the court has made?
In terms of the reasonable and necessary component, yes,
Okay.
absolutely. How can it be necessary, much less reasonable, to impose regulatory requirements if there has been no finding that a permittee has a duty to alter its behavior based on actual evidence that it's contributing to a problem? And to borrow Mr. Held's analogy, he said that, oh, well, you'd put a cloth on a cut if you, even though you might need stitches later. We don't even know that DeKalb has a cut. To put his analogy to its logical extension, it may be the person standing next to me who's got the cut, but DeKalb's got to put the cloth on its arm, under his analogy.
And what other findings of fact or assumptions, et cetera, that are contained in and that the ALJ's underlying decision was reliant on, would you point me to specifically that are lacking here, for which there is no evidence in the record?
The point I would make is that what we would expect to see if would be, oh, we've got a reasonable potential analysis in the record. We understand exactly what the receiving water body can bear. We understand exactly what DeKalb is discharging, and we know exactly what limit we need to place on DeKalb based on all of the other dischargers upstream of Lake Jackson.
Right, but I know I asked a lot of questions about the RPA, but as I understand it, the absence of an RPA, right, from your perspective, is ultimately is part of the argument that this entire thing is legally deficient, right? Because I think I understand this isn't, if it's a BMP, no RPA. Can't believe I'm rattling off these things. If it's a BMP, then no RPA is required, right? Which is, and the position, at least in part of the EPD, is that it's a BMP, and so there's no RPA required. And so while I understand that you believe the record lacks an RPA, if the court finds that this is in fact a best management practice, then no RPA is required, right?
No RPA would be required as a matter of law.
Right.
But an RPA would be evidence that you would still expect to see to make it a reasonable and necessary requirement.
Because that document would provide the evidence you're talking about that is lacking, which would demonstrate the scale and scope of contribution by DeKalb County to the harm or ill that is being sought to be protected here.
That's correct, Your Honor.
Okay.
And I apologize for sort of the flow chart of logic, but there is
no, that it makes complete sense. If there were, if all the logic was clear, then none of us would all have jobs, right?
That's
So,
true. God forbid that AI is going to take all of our jobs away from us.
yeah, I certainly hope not, Mr. Droz. So back to my original question, because
Yes,
so
ma'am.
I asked you one question so far. You've given me two, you've pointed to two things. One is the absence of any evidence that DeKalb is contributing to the problem in Lake Jackson, and or at what scale, and the absence of an RPA, which would provide evidence of whether or not and the scale that our DeKalb is contributing. Any other specific places you want to direct me to that are not, for which there is no evidence, or that where, that the ALJ's legal findings sort of skip over?
I'll just run back through them then very quickly, Your Honor. Mr. Held referenced paragraphs 3 and 9 about there being too many nutrients, and he noted chlorophyll A can be measured. Well, nowhere in paragraph 3 and 9 is there any evidence that DeKalb County is responsible for the too many nutrients. So there is no finding, because there is no evidence that DeKalb County, who discharged into a non-impaired stream, is contributing any scientifically measurable amount to the quote unquote too many nutrients in paragraphs 3 and 9 that are being referenced. Paragraph 11, the notation is, well, Lake Jackson was impaired. With due respect, so what? We don't directly discharge into Lake Jackson. So, and it's undisputed that the South River that we do directly discharge to is not currently listed as an impaired stream for nutrients. So that, again, it gives lip service to some things that support EPD's argument, but it ignores the absence of evidence that links DeKalb County's conduct or discharges to the problem itself. Paragraph 15 was referenced about, oh, well, it's possible to do something now. Well, that's a legal conclusion. That's not even a factual finding. There's no indication, again, that what is it that DeKalb County is supposed to do now based on science. So those would be additional points that I would make, Your Honor, with regard to those. Some of the factual findings are, again, sort of a so what, because they omit the key point of where's DeKalb in all this, which an RPA or other scientific evidence would supply.
Okay.
Let me close with a couple of short points. I want to go back to, just for a minute, this home rule constitutional provision. I think Constitution trumps everything else. So even if there's a legally issued permit, if it doesn't meet the terms of a constitutional provision, you lose. So there is a world where the court could find that even if the language in the CNOP could be upheld legally or factually, that it is nonetheless so vague that it's compelling behavior by DeKalb County that is otherwise reserved to DeKalb County in terms of its home rule powers. So there is a difference between the constitutional requirement and the permit. So I do disagree with the suggestion that it's a binary equation. There is a constitutional argument that exists regardless of whether or not there's a legal issue permit. And then just very briefly, I did just want to touch on the fact that DeKalb could not force the ALJ to do an in-camera review. So the fact that the ALJ did not do that, even though we asked for it, is not our fault. We can't waive something that we can't compel the ALJ to do. And
well, I think I'm more interested in the fact that there's a good bit of discussion about whether you waived anything, but if there is, I mean, there might be a permitting file, but it doesn't seem to be in dispute that there's not an investigative file. And so whether there was anything to be reviewed, I mean, that's what I understand Judge Howells to have determined, is that there wasn't there wasn't an investigative file, and that this was not a contested case in the understanding of those discovery provisions.
Well, we disagree that it was not a contested case. If it were not a contested case, it would not have been before OSA to begin with.
Sure.
That's you knock on the door if it's a contested case and you get to come inside if it is. If it's not, it gets discharged. So we think it was a contested case. And we would analogize the investigative file to the permitting file and say that the whole basis for the policy that is attempted to be vindicated by EPD is what's in that permitting file. What is the policy behind making every NPDES nutrient discharger in the state have to deal with these CNOP provisions? Let's see, show your work. So in any event, I'm not going to belabor that point. But I did want to just touch on the fact that I don't think that there was a waiver involved. So, Your Honor, thank you very much. You have been very patient. You have given us now, goodness, almost 3 hours of your time. And I very much appreciate you spending the background and looking at this and
Well, I
asking.
appreciate it. The reason that I was happy to set this aside on a Friday is that there was no way that we were going to get through this with my having the ability to try and understand it in an hour or whatever. So I fully expected that this was what was going to be my morning. And so thank you all for nicely keeping yourself inside the part of time that I had set aside, which was from 9 to 12. So here we are. So I'm not going to rule in any way entirely today, right? I am going to ask for a couple of things and tell you a couple of things I am comfortable saying what my ruling might be. So number one, I think I've made clear that I don't see any basis to disagree with Judge Howell's finding regarding the production of any permitting file or investigative file. Also think I've made clear that it's not because I think anybody waived anything. I think it's because the provisions that were at issue, on which the parties were relying to obtain that information, are contested case investigative files that might result in the loss of a permit, not permitting disputes about what's required. At least I think that's what I understand. But to the extent I've said anything that's not exactly legally accurate, the point is I agree and would affirm Judge Howell's finding on that point. As to the issue of home rule, I understand the argument that DeKalb County is trying to make because, of course, certainly county is authorized. I mean, it has the protection of home rule, but I think I agree with the EPD here that this is not the type of, that this regulatory structure is not what was intended to be protected against under home rule. And so by that, what I am saying is, as odd as it sounds, I think the Attorney General's office is correct that it is a heads I win, tails you lose proposition, right? That home rule doesn't change the outcome here, whether I rule in favor of DeKalb or rule against DeKalb. That home rule, I don't think, is an answer to the question, because, as Mr. Held pointed out, these are validly enacted federal laws and regulations. And albeit the allegation that the CNOP is vague, the regulatory structure itself is valid and enforceable. And so for that reason, I'm not persuaded that the home rule argument changes the outcome here either way. So that leaves me with the actual substance of Judge Howell's ruling in terms of her final decision and whether it was improper and should be reversed or whether it was proper and should be affirmed. And so I'm gonna tell you a little bit about my thinking, and then I'm gonna ask y'all to do this. The reason I outlined the things I'm definitely not going to do is because I'm gonna ask both parties to submit a proposed order. And I need you to submit it in Word format to Mr. Freehoff so that I can edit it. And besides those two issues, I guess the what I'll get to is this. I don't think, as I understand the parties' positions, the focus here in terms of the standard that the court is to apply when reviewing a decision of an administrative law judge, of the 6 factors the court looks at, right? What we're really talking about is whether Judge Howells made an error of law, right? Whether Judge Howell's decisions were clearly erroneous and or arbitrary and capricious based on a lack of any evidence in the record to support those findings. And so that's really where I'm going to be focusing my evaluation, because I don't think anybody's made any arguments that she exceeded her authority, or that she engaged in some sort of unlawful process, or that her decision violates some sort of constitutional statutory provision, except for maybe that home rule thing, but that we're going to push that off to the side. And so the reason I give you that outline is that that's really where I'm looking. The parties have given me a lot, and as I would expect quite able counsel to do, is to cover everything they can think of that the court might be focused on. But for now, in an order, what I'm going to tell you is I'm either going to enter an order that says, I think that applying the appellate standard that's appropriate, either Judge Howells made findings of fact that were not supported by the record, by any evidence in the record, right? Or that she made, and therefore her decisions were either or both clearly erroneous and arbitrary and capricious, or that she made an error of law, or I'm going to find that I don't believe she made an error of law, or that she misapplied the law as I understand it, and that the facts that exist in the record are supported, her decisions are supported by some evidence in the record, which is what I understand the standard to be. And so I say all that, and then I'm going to ask if you have any questions so that you understand sort of, I'm trying to provide you with a little bit of framework so that you don't have to just retool the motions that you've already filed. Because I really am looking for something that is a little narrower, because thankfully I don't have to get into the details of the details on the granular level that Judge Howell's decision does, right? What I have to look at is whether there is any evidence to support the decision that she made, and whether or not she made any error of law or was arbitrary and capricious in reaching her decision. So that's my goal. Do you guys have any questions about anything else that would help you understand those parameters in my instructions, other than we should probably work out a date by which I would expect y'all to get that to me? And I promise I don't want it later today or Monday, right? I'm planning to be reasonable about when you might put that together. Mr. Held, Mr. Droz?
The only question I have, Your Honor, is I understand what you want the order to focus on. Do you want us to include your rulings about the home rule and the Rule 37? Okay.
Yes.
That will not be the focus, but I just want to make sure you want them in there.
Yes. Mr. Droz, any questions?
I don't think so, Your Honor. I understand the court's instruction. I just sort of note that I think the clearly erroneous and the arbitrary and capricious are separate standards, and
they are
the excess of statutory authority issue that we do think is out there. But I understand the court's instructions, and I think we can narrow it based on what you have.
And admittedly, I've probably tripped over myself a little bit, but basically what I was trying to say is, if there are 6 things that I'm really supposed to be looking at in terms of whether or not Judge Howell's decision was wrong in some manner that requires reversal, then I'm not really looking at the first 3. I'm really focusing on those last 3 items. And so to the extent that my language was imprecise in that way, I apologize.
No worries. I understand. I just want to make sure that I understood the court's instructions. So thank you.
No problem. Thank you all very much. Unless you need anything else from me, it is noon, and I hope everybody has a great weekend. We are adjourned.
You too, Your Honor.
Okay, we are off the record at 12 p.m. And I do have one quick question before everybody logs off.
I don't think you need the judge, do you?
Yep. I'm going to log out, but I'm just Mr. Freehoff, just making sure don't turn off the Zoom, because then they'll all lose each other. Thank you. I'm logging out.
All right. Thank you. I just need to know, the judge, is it Howell or House or?
Howells, Howells.
All right. That is my only question. I just wanted to make sure that judge's name was spelled correctly.
That's a good thing to do. Thank you very much.
Thank you very much. Y'all have a great afternoon.
Chris, the judge didn't give us a timeline for.
I was trying to cut in at the end there, but yeah, I assume
Hi, all.
Mr. Freehoff's on here. Yeah.
Would you like me to contact the judge on her cell phone and get a deadline?
That
Or
would be
would you-
great, or you can
Or
let us
just-
know by email.
Yeah.
Okay.
whatever's-
That's what I was going to suggest.
All right, I will find out and I will email it to you later.
That's great. Thank you so much,
Thank you
Mr.
very much.
Freehoff.
No problem. Bye-bye.